Because then, Danny, just a quick one. Will you give us a heads up then on a comfort break? I don't know if there's a 10-minute, I remember at the War Memorial, this was the brilliant tea breaks and SAMIs. Do you take a break as well?
Yes, we will. We'll take a break whenever you, I don't know, do you want to do it an hour and a half? So perhaps
yeah, shall we do that? Okay, yeah, perfect.
It's good. Welcome everyone who's joining. We'll wait for everyone else to join. It's still only 3 minutes to 1. So give everyone a bit of time to join in. Have we lost Cheryl? Hi and welcome everyone. We are having a few technical issues. I think we've lost Cheryl and her presentation. I'm just going to try to get hold of her and welcome her back. But in the meantime, I'm also waiting for everyone else to join in. And
I was there and I disappeared. I don't know what happened.
yeah, I was watching and then I think it just disappeared and I was starting to stress. Welcome
so
back.
You know what I've done? I'm working on my personal hotspot, so there shouldn't be an issue with the Wi-Fi. It's all connected. We were there and we disappeared. Sorry.
Yeah.
So let me just call up my screen again and from the beginning. All right.
I don't know how many more. I'm still getting a few people struggling to get in. So give it another 2 more minutes.
No problem.
And then we'll start. I'll just do our usual. We're going to be taking questions throughout. So if you want, please just ask a question in the Q&A section. Otherwise, we can always raise at the end if you want to ask something without typing it out. And if it's easier to speak your question, we can wait till the end, and I can allow you to speak if you so need to. Stan has
the attendees. There's some old faces. It's nice to see some old faces.
Yeah.
Sorry, Danny.
Yeah, it's a good usual crowd. Now I'll give it 1 more minute and then we'll start. Still people joining, I can see. I hope everyone received their invoices for the seminar. I'll do all the admin afterwards, and it's going to be a bit fun and games because we have Jackie at Orrington next week. So it's tying up all the payments for who's paying for this seminar and who's paying for next week. But we'll manage and we'll get it all done, and in between still send your certificate out hopefully before Jackie's. And then we have one more in 3 weeks time, and the first week of December we have an ethics seminar for those who still need to get their ethics CPD points in. All right, I think let me hand over to Cheryl and take it away.
Hi, thank you, Danny. Hi, good afternoon, everybody. It's nice to see some old faces. The nature of today's presentation is not going to be technical as such. We're not necessarily going to go through any sections. It's more a practical look at estate planning and wills. I've covered both the local as well as the offshore component. And what I do want to say is any of the examples that I give or the solutions to an example, just remember they all bespoke, because you can have, I always say when somebody says, hey, what do you like about your job? I always say 2 things. One, on the basis that you can have mum, pop, and 2 kids times 4 families, and every single family would be different in that the one family it might have let's say, for instance, a mentally challenged child, and therefore you need to plan accordingly. In the other one, you might have one child overseas and one child local, so you need to plan. In a third one, mum might be stepmom as such, and dad wants to leave the money to mum first, stepmom first, and then ultimately to the 2 children. But he wants to make sure that that normal line that the guys always say, I don't want my wife running away with a poor man. So every scenario, every family and estate plan that you have a look at is very, very different. And then the second thing I say I love about my job is to hear about the black sheep in the family and then know that my family is actually quite normal. So let's have a look at an outline of the presentation today. I'm going to start off with where do you actually start the estate plan and what are the hard questions you ask? Understanding the building blocks of an estate plan, looking at the personal assets in the living L&D account, the trust and its role in the plan, including a letter of wishes and intent, and then the will, local and foreign implications. I do want to say, and if that's all these disclaimers that one needs to make, in connection with the letter of intent and the wishes, if you have a look, I added a copy that I've used for one of my clients, and we can have a look at it when we discuss the letter of wishes. Because in my mind, the letter of wishes that are being circulated and everybody seems to be copying and pasting are actually very iffy and they don't provide much information. So starting off, the first thing is to actually get to know your client. I actually have started to mentor a young lady that I worked with years ago, and she's now gone out setting up her own business. And she said to me, what are the first two things that I need to do? And I said, at the end of the day, your client relationship is built on trust and spending time with the client. And even if it's unbillable time, to actually cement that relationship, get to know your client and ask those hard questions. Remember, you don't have to be at the family Christmas party or the dinner party. So if you're going to be the bad cop as such, because the advice that you're giving or the recommendations that you're giving are not palatable to, let's say, Johnny, who keeps nagging dad and wanting to dip into the family funds or get low interest-free loans or interest-free loans, you can play that devil's advocate, and you can also be the bad cop, and you can actually put your foot down, bearing in mind that you need to give the best advice and be impartial and balance and consider the family as a whole. I know the impartial and balanced is quite difficult. I've got a family that I've been looking after now for going on the 4th generation, and the uncle now, the son, who's in his 70s, is a really miserable old bugger. And when I see his name pop up on my cell phone, I know he's going to ask for something, and immediately I just want to say there are no funds available within this trust, or we'll have to put it through to the trustees. And that's just purely because I think he's a cantankerous old man. But again, I've got to stop and say, be impartial, take emotions out. It's not your money. Give the best advice, consider the family as a whole. The other one is knowing when to listen. It's as important as asking those questions. And if you can, and I hope I don't offend anybody or say anything incorrectly within the presentation, but so often I've sat on estate plans for farmers, and dad is the patriarch and mom sits in the kitchen and doesn't say very much. You need to listen to or keep an eye out and look at mom's body language or mom's view, what she doesn't say when dad says, oh, I want the monies to go to my son, or if a child doesn't get married to within the same religion, then they're going to be taken out of the will. See and listen and have a look and see what's not being said as such. So much of our job as estate planners and financial planners is actually more, I want to say, being a psychologist or having empathy than it is actually putting the numbers and doing the calculations. That's actually the easiest part of our job. The other one is don't be the reason for the family feud one day. Ask questions and play devil's advocate. And a big one, and folks, you know what, with all the gray hair and 30 years of being in estate planning, in the last 3 months, I've made a fundamental mistake as well with regards to, it's not a family feud, but I should have actually spoken up when the investment advisor said, just be sensitive. And I'll quickly give you an example so you can understand. I've got mum who had leukemia, going through cancer treatment. Dad got throat cancer in November. Dad died in April. Mum, through leukemia treatment, got COVID and she died in August. And when dad was sick in January, February, we said to the investment advisor, let's review, let's visit that will, let's set up the testamentary trust. Then when dad died, it was a case, well, mum we needed to have a positive outlook. And the hard questions that I wanted to ask to say, you've got 2 daughters that if you don't do something, we're going to end up in a mess. And unfortunately, I listened on the basis of being sensitive and being positive to mum. We didn't settle the will as we could have. Fortunately, it hasn't cost us in the form of taxes and estate duty. What it has cost is a bit of stress in that the way the estate is now unpacking, the pension won't pay to the beneficiaries, it's paying directly to the state. And you know the problems that we're having with getting letters of executorship. You know the hassles to open any bank accounts for estates and all the KYC to get anything paid. So I've got 2 young daughters who at the moment we're now begging, stealing, and borrowing money in order to fund their living requirements, where if I'd asked those questions 2 months ago or 3 months ago, we wouldn't be in this situation. So go with your gut feel and ask those questions and play devil's advocate if need be. And then remember, this is an intimate personal relationship built on trust and time. Questions that you need to ask, and that comes in quite often if there's second marriages, or if you're in a situation where there's married children who've got stepchildren as such. Ask the question on the basis of, if you're doing the will or if you're setting up the trust, does it include spouses and or former spouses? What happens if there's a civil partnership? Who are those significant other half? Ask the un-PC questions. I've had 2 instances where I've challenged the estate planner on the basis that he said he's got a gay daughter, and as far as he was concerned, for as long as she was gay, there was not going to be any distribution to her. And in that, you sit down and say to the person, and that comes back to, don't be the reason for the family feud. Sit down and say to the client, put yourself in your child's shoes in 10 or 20 years time. When you die and they don't get anything, how are they going to feel about it? What is the feelings? And try and unpack. And if you see a client, and I know it is their will and I know it is their document, but if you've seen something that could have lasting impacts, raise those questions. I've seen over the 30 years of winding up deceased estates where dad's appointed the elder son as the executor. Elder son is actually an artist who is a dope smoker, who is so not interested in finance. But the youngest daughter is busy with a BCom degree, and you find he still he still makes the older son because that's the way the family goes. Raise the questions. I've also been in a situation from a trust point of view where they've only included one child as opposed to all of them. And those kids are, once mom and dad have died, you've had the question, didn't dad trust me? Or why wasn't I included? Or why is my brother now in charge? Or if it's my sister, or quite often sister's husband, why is he in charge? So again, just understand try and think about what the impacts would be from a family perspective. As I said, then there's also the black sheep and the delinquent. Everybody has a normal dysfunctional family, and as I say, it's quite refreshing to see that one's actually normal. Look at a child as a stepchild, adopted as a minor or adopted as an adult, and what are the implications? Because very often given the mix of the modern family that we have nowadays, you'll probably find one of those in just about every estate plan. And then the other one, including close friends or professional advisors who've developed a relationship with the individual family members. Do you bring that person on? What is the role of that person one day? And get an understanding so that it can be communicated. Often I'm asked the question both by professional members such as yourself and all the clients is, when do we have that hard conversation with our children? For instance, I've got a client, and in fact that letter that I've attached to presentation as an example is because come December, there's going to be a bus parade down at the beach. The son's now got involved in the business. Dad wants to go through and explain to the kids what has happened as the family is concerned. So to answer the question, you need to, Danny?
Yeah, I think you were breaking up there for a second. I don't know if you want to just repeat that section again. Just lost you for a second.
Sorry, buddy. So where did I was going on the basis of a bus parade, and actually having family bus parades, not a bad thing then, and educate and tell the children about, you don't have to necessarily give figures as such, but certainly give types of assets or what your intention is with regards to those assets. Coming down to the next one, you need to then just have a look and say, where are we in the process now? Very often you might start with the accounting and the tax compliance. Then you might add the trustees, the fiduciary services such as trustee and executor. Then you sometimes get roped into the estate planning. A big one then becomes business succession if there's a family business as such, investment planning, and it's something that I've never ever got involved in. I've always left it to an independent party, but it might be something that you're involved with. And then ultimately there could be the establishment of a family office, or literally dealing with somebody within a multiple family office. Just the difference between a single family and a multiple family office. A single family is exactly like that. The Oppermans have a family office. The Harrises have a family office. A multiple family office might be, for instance, something that I run, where I look after 4 big families. I'm the CFO as such of the individual families, but it's all within a not dedicated to any one person. So what is the type and what do we look at for the information gathering? The first one is to start with a family history if you can. And a family history is quite important because it also gives you an indication of where the family might end up with regards to doing the estate planning. And when I say end up, on the basis of, if dad then says, or granddad says he was a immigrant that came to South Africa after the war, and with literally the clothes on his back, and he's developed a portfolio and a family business, etc., then you can kind of figure that at the end of the day, any distributions or any structuring he makes, he's going to want the kids to put in their pound and have skin in the game. It's not going to be a case of, well, here's the silver spoon as such, do your thing. So understanding who the family is, and ask the nature of the family. I've got a client on a deathbed who said to me, my daughter's husband is going to, as on our death, or she was the first surviving, or last surviving rather, the daughter's husband's going to come tapping for funds, and my son's going to blow it. And if there was one person who actually knew her children, it was her. And ask the individuals or planners, how do they perceive, or what do they see the children in the form of giving them inheritance one day? And if it's the case of that one child might have their distribution outright and the other might be in a testamentary trust, or a trust that's got limited capacity in order to make awards, that's also okay if the objective is to make sure that the family is well looked after, the assets are protected, and there's succession planning. I deal with 2 clients where in one instance it's the son that's got it, and he's so angry that his mom's given him the fund, hasn't given him access to the funds, but the way he blows it every now and again, I've got to say to him, aren't you glad that you can still buy your bread and water and live, that you didn't blow the money, and that's why mom did the trust. And another one who she just, her view was her dad put her monies into a trust because he didn't like her husband. So again, just, and you can hear on her instance, there's a little bit of bitterness. She's a lady now in her 70s. The trust was formed in the late 80s, and there's still a unhappiness. So again, be careful and be sensitive to what your client wants to do. And if you don't think that it's going to be relevant or sustainable, the decisions that are made might change in the future, then raise that with your client. I'm going to give you a silly example, but the example is, I give my red VW to my son. You don't know if that red VW is going to be sold in the near future or written off, or whatever the case is. So ask the question, are you going to have the red VW for a long time? Or if you make the call of putting monies into a trust because you don't like your daughter's husband, do you want to unpack it after that? Or folks, I see it's coming up in unstable, but I promise you I'm on my hotspot. I hope everybody can hear me all right. The other one then is having a look at the family legal architecture diagram and associated legal agreements. So in other words, have a look at what does the family structure look like. And sorry, I've done a legal architect diagram and a family financial diagram. The financial one is obviously dealing with the assets, the legal structure, and that we'll have a look at when we look at the building blocks of an estate. But it is, have a look and see, is there a trust in place? Are there family companies? Are the companies held within a trust company structure, or are the shares held directly by the individual? Again, to give you another example, and that I think I put that as one of my tips and tricks later on, is years ago, and I want to say not so much nowadays because there's so much KYC and so much documentation that goes out, but a while back, people kind of set up companies or CCs because it was the right thing to do, and you put all your properties in a property per CC. I'm assisting a client now where mum has died. There's 4 properties that are now being distributed, 4 blocks of flats, and the kids all thought that the blocks of flats were actually held by mum in a personal capacity. We've now found out that 1 is in a personal capacity, 2 are in CCs, and a 3rd one is in a company. And the problem with the company is because she never maintained any records or any submitted annual returns, that company is now non-compliant as far as CIPC is concerned. And clearly there's an issue as far as taxes is concerned, and trying to actually patch up and see what was the rental, what were the expenses, etc. Because all of those properties and the CC and the company were held in a personal name, either through the structure or the held directly. And now we're busy playing join the dots as far as understanding or trying to actually put make all those individual entities tax compliant so that we can wind up the estate. And by doing that, we've probably added on, if I tell you that we've been going on probably for about 18 months already, we've added on extra 18 months in winding up the estate because we need that information from a SARS perspective. So it's a good thing to ask those questions, have a look at the legal structure. And then from a financial point of view, have a look and see, often there are loans that are made to family members, or there might be dad set up and put the daughter into a business as such, but he's taken a percentage interest in that business. And his intention always was, I just want an interest in the business because it kind of keeps you on the straight and narrow, if that's how dads talk. And then 20 years down the line, the daughter's got an amazing business going. They forget that dad still got that percentage interest. And then on his death, you then come to that his assets become residual, and a portion of the daughter's business that really is hers because of her blood, sweat, and tears, unfortunately then gets split amongst her siblings. And then you've got to enter into redistribution agreements or do some additional planning. And all of that just adds time in winding up the estate. And if you think about it, and I know this is a really crappy comment to make, but that's why we're in business, you actually want to wind up the estate as quick as possible, tax efficiently without any dry taxes. And I'll go through the dry taxes with you. And to the best advantage of the family members so that you can take your fee and you don't want it to drag on forever. Because remember, you're essentially almost the last person to get paid as the executor of the estate. Then have a look at the as is. So have a look at who are the institutions involved? Are they local or offshore? Has dad, the relationship as such, you might find in the old days, if there was offshore investment advisors, because of the exchange control restrictions then at that point in time, mum and dad always met the financial advisor on their trip to Italy or to Spain or wherever, and they've got a relationship with the investment advisor who's probably as old as mum and dad, and they haven't passed and given that information on. So it's good to see who are the role players, also from a family perspective. On the death of mum and dad, if mum was the matriarch, identify and see who's going to be the person that will help the best in unpacking the estate and dealing with any potential family feud. It's nice to have sort of a family spokesman to go to and say, look, we've got the problem, we've got an asset, let's say, for instance, a property that now needs to be distributed amongst 8 people. Here's a suggestion or solution, and you want one person to be able to go and speak to the 7 other beneficiaries rather than you dealing with 8 people and 8 views and answering 8 times questions. So have a look at who the role players are. And then, as I said, you'll see I repeat the identification of the structures. That's really important. I've kind of covered how is the family led, and then who will lead on the death of mom or dad. And then a big one for family business, is there a succession plan in place? Often, especially with the farmers, and I've recently had one now at the moment where the farmers actually, dad and mom on the death assume that the oldest son is now going to go and end up farming. Actually, the oldest son is actually a chemical engineer. Is that what he's doing? He's now based in the city, and there is no way that Oak's going back to the family farm as such. And now we're sitting in the quandary with how we do the planning. So again, deal with those questions as and when they arrive. It means that when you have to come and wind up the estate, it's not as hectic. Just in connection with where do we address these? Now, I want to have a look at, for instance, the family bank is a big one. The other ones might be education, folks, is becoming more relevant. And I see there's a lot of questions that are asked from an education perspective, in that nowadays you tend to find that kids do their post-grad education overseas, or even their tertiary education, their B grad overseas, and there needs to be planning as such and cash flows available. Family bank, I always love that one when somebody says, when each of my grandchildren attain the age of 21, or my children attain the age of 21, buy them a car. Well, the expectations of dad having the VW Beetle versus the child who wants the GTI, manage those expectations and understand also from a family bank point of view. It's quite nice, as I say, going back to, you don't have to be at the family dinner as such. So I've got a client where as soon as his son keeps coming in and asking for money, he's very happy to say yes, yes, yes. And then every now and again he gets the zig in, and then he says to me, it's no now. And he always defers. From the start, the relationship was, I've got to put it through the trustees. Let's have a look. From a trustee point of view, we would examine, yeah, it makes sense. Dad was happy to loan the money, and we would do it. Where he gets the zig in and says no, we then manage it in the form of either we don't have the liquidity available, or we're not prepared to sell any assets because of the tenant capital gain or the tenant cost. So actually, son, you're out on your own. Succession plan, role of the advisor and the brains. Wealth planning as such, that's not my area of expertise. It's always good to get an independent person in. For instance, again, in a planning one, we've got a situation where it's quite nice. I've had the investment portfolio manager come to me to say, can we sit down with the client, because the way she's spending at the moment, this house is not, the portfolio is not going to manage a lifespan of more than 9 years. If you take into account her life expectancy, it's 15 years. And the problem is this big, massive family home that she wants to keep. And so part of the planning, the investment advisor saying to me, I've got a problem with cash flows. And the two of us went to go and sit with the client and say, look, it's actually time you now solve this house. You're one person rambling in it. We understand how magic it is to have the family at the house, but actually it's costing you, and in 8 years' time, you're not going to live. So again, folks, can you see it comes back to hard questions? You've got to be impartial, practical, and sometimes hard, because you can see the the black and white figures as such, but always be empathetic. Managing conflict, I will, again, to this day say, I will never, never, ever be surprised ever again of when you have a death and when you have money. There will always be conflict. And the person that you think is going to give you the most hassle sometimes is the lamb, and the lamb during mom and dad's lifetime becomes that flippin' absolute dragon, and you deal with absolute disaster from that point of view. So understand the conflict scenario. If need be, call in independent people to assist with conflict. I've had a few instances we've actually called in an arbitrator. And there was something else I wanted to say with managing conflict, and it slipped my mind. It'll come back. But managing conflict is probably the biggest one as far as doing an estate plan, and then the distribution after the death, essentially. And I always go back to mom and pop. After the death of the two main planners, it becomes a challenge. The other one is family shared assets. Family shared assets could be the beach house, it could be the home, or it could also be a shared portfolio that has been set up for the benefit of the grandchildren. And again, to give an example with a real life case that we're dealing with, we've got a share portfolio that the granddad set up years ago. The kids are now, there's 7 kids, with 2 in Australia, 4 in South Africa, and 3 in the States. And to pay the money, we can, from a distribution point of view, we're using investment allowances, so that's not a problem. But that shared portfolio as such, that was built for the benefit, or formed for the benefit of all grandchildren, is now being severely depleted by family members who are overseas. So again, just have a look and see whether at that point in time you don't make the call. And again, I've used it and suggested to clients, if you've got family overseas, stop the bleeding as far as keeping a South African asset that's going to manage an offshore expectation, whether it's an inheritance or whether it's income, and maybe actually distribute it already offshore. Obviously go through the correct channels from a Reserve Bank perspective. Be very careful. And I want to raise that now because it popped up again last week. Very often people will take out foreign investment allowances and then make them at the disposal or the availability to another South African who hasn't formally immigrated abroad. That's actually a breach of exchange control. So you can't take out, A can't take out his foreign investment allowance and then give it to, I know you're allowed to do with whatever you want to, but put it into an investment, even if it's a joint investment overseas with is also a South African resident. That is a breach of exchange to manage assets or making vestings and distributions. Be careful of exchange control and you're not breaching anything on that side. Then we come back into the basis. Sorry, I'm just checking. Yeah, what is it that we want to achieve? Continuity for the family, and sometimes maybe beyond 4 generations. Nowadays, let me check my Wi-Fi. Nowadays, managing the expectations beyond 4 generations, it's very slim unless it's a massive family business or there's extensive wealth as such. What is the purpose? And that's really, I want to say, is it this becomes quite philosophical, is it the pursuit of happiness? And then questions that we want to understand and you need to pack out with the clients is, what is continuity? What is preservation? Who is family? What
Cheryl, you're breaking up again.
In to account as part of my happiness. How's this, folks? Sorry.
Do you want to maybe, Cheryl, just to maybe to make it maybe easy, do you want to maybe turn your video off, and then we'll just hear you. It should might help them. That might help.
Okay, let me do that. Sorry, everybody. All right, is that better? I'm looking at the Wi-Fi and it's there. I'm so sorry. So I'll just repeat then, what do we mean by continuity, preservation, and is the preservation longer than 1 or 2 generations? Who is the family? Does it include extended family, step family as such? What is wealth and what are you going to keep in that pot as such? And then what is happiness? Is happiness on the fact that you can then actually give that child that silver spoon, and the child doesn't necessarily need to do anything. I know Warren Buffett, and I'm going to quote it completely wrong, but the essence is he basically says, give your kids enough that they are, they've got some content, but not enough that they actually do nothing. So, have a look, and as I say, everybody's definition of those are different, both within the family and also yours. So be careful your bias doesn't come through in any of the planning. This is just quite a fun diagram, and I like always the bottom portion as to what starts at the dining room table and then you move to the boardroom table, what then happens at the family retreat as such, or the Bosbarat in the family farm or the beach house, and then ultimately where you have the private trust company and or the family office. So really your decision makers, the family decision makers, are usually the founders as such, and they can be wealth in some instances, although I want to say not as frequently nowadays do we come across it, but years ago in the form of you had clients who had huge corporate wealth. I'm going to use the SAB staff now at the moment with the whole unbundling with the ABNI. I've got friends who in their late 50s now have made buckets full of money out of the SAB unbundling as such, and they've all kind of gone into retirement, but their retirement has taken them into private equity ventures. So they've kind of jumped from the dining room to the boardroom table because they're going into real estate and they're setting up private equity ventures and family businesses. So your founder doesn't necessarily have to be an entrepreneur who started the family business of whatever nature it is. The dining table, you kind of find it's a very simple structure in that there's the business and the trust. And then as it becomes more complicated, there might be additional businesses. A big one is family foundations and philanthropic foundations. And I know a lot of people are going on the basis of not necessarily doing donations, but I've certainly seen it in will drafting over the last number of years, where people have either set up their own foundation in the form of being able to support and educate previously disadvantaged, or they literally plug into an already established foundation. And to give you an example, if you contact the universities, they have numerous trust funds that have been set up that you don't necessarily now need to have the cost of setting up your own. And I've been involved in an electrical engineer one where somebody wants to sponsor some postgrad electrical engineers, and have suggested a thesis topic. Wits have actually been superb in being able to assist on that. So if you do anything in the form of the philanthropical foundations, you don't necessarily need to reinvent the wheel. On the private equity side, again, you can have a look. There's often clients that will say they give angel finance, or they take an equity stake and they help and assist build up the business as such, or it's a case then of just throwing money at the problem and hoping that they've got enough private equity people out there, they're comfortable with making an allocation of money to private equity, and they don't really worry about it's a direct investment, and they don't really necessarily worry about a return. So again, just to understand and have a look at where your client is in this in these stages. Then for me, the biggest one is actually understanding the building blocks of an estate. And that for me is the pivot on any form of estate planning. You have a look and see what are your personal assets, or the assets that are held within the estate, what are trust assets, what are corporate assets, and corporate assets could either be held directly by the individual or it could be held within a trust structure. And then there's assurance, deemed assets, and retirement assets. So folks, let's have a unpack and look at each of these 4 silos as such. I don't see anything in the form of questions, so I'm assuming everybody's happy and we're fine on that side. Right, on the personal balance sheet, take into account there's a tax statement of assets and liabilities and a personal balance sheet. And I am going to tell you now that in the last few estates that I've been involved with, the SARS deceased estate department has gone back to have a look at the assets and liabilities that the individual reflected on his or her IT12 during the years. And they are questioning why assets were not reflected on the statement of assets and liabilities. And you obviously know the natural question that will come through. Was there any income and or capital gains that should have been reflected on these assets, not on the tax statements? So often clients will say, oh, I haven't submitted anything to SARS. If that's the case, it's okay. If they have submitted something to SARS, get that personal balance sheet, if you don't do the tax return, get the tax statement of assets and liabilities and check it. Another one that SARS have used in the form of artworks is the insurance and the replacement value of those assets. So you might just put in and say assets of no commercial personal assets or artworks of no commercial value. If SARS calls for, when they're doing an assessment of your L&D account and they call for the insurance policy and you're sitting with a sizable reinsurance or insurance value on Persian carpets and artworks, you are going to run into trouble. You'll see further on, I'll talk about the living L&D account, and I like to keep the values at cost and not so much insurance value, because that's it's a good to know if you're dealing with somebody who's got large artworks and or I want to say investment costs. Otherwise, the insurance placement value is just a ballpark. But do the base cost for capital gains and do a market value. Market value is just to give you an idea. Then when you come to do cash flows one day, and base cost allows you to do those CGT calculations on death. What I want to do in connection with base cost, and I gave a presentation a little while back, and it was on selling of businesses. And for those of you who remember the 2001 capital gains, the introduction of capital gains, we had a window period of 3 years in where if an asset was valued over 10 million or a property was over 10 million or I forgot what the 1 million one was now, forgive me on that, but you actually had to get a formal valuation, and that formal valuation had to be lodged with SARS in your last return by 2004. So you had 3 years. In capital gains was introduced in 2001, and you had to submit the valuation to SARS. If you're now in the planning process and you've had clients that you've had since 2001, you'll either find that they are dying or they're exiting and retiring out their businesses, and you need to ask those questions. Was a base cost valuation done in 2001? And if so, where is it? Because if you don't have that, the availability or the capital gains calculations that are available are quite onerous, in that you just get the time apportionment basis or you get proceeds at 20%. So again, just and with each of those, know when to use which one. Then have a look at the ownership of assets, whether it's held jointly by mom and pop, or pop and son, or pop and uncle, or mom and a friend. These are all players in the estate planning function. who then, I want to say, I've said here, their own idiosyncrasy and the normal dysfunctional as such. So see who the asset is held with, and how you're going to unpack and deal with it, and especially if there's an untimely death or an exit as such. And then the other one is deemed assets, but that will have a look under assurance and the retirement assets. Just a quick one. I thought that the assets on IT12 are on cost and the L&D market, so these two documents are not necessarily same. Agreed. So you're right. The statement of assets and liabilities for tax purposes is at cost, and an L&D account is at market value. But run the two schedules simultaneously, that you can kind of pick up cost, because sometimes cost is your base cost. Because remember, when you come to do your L&D account, you're going to have a deemed CGT event. And when you've got that deemed CGT event, you need to know the base cost of the asset and the market value, and essentially, and it's the market value at date of death. So you will need those two figures at some point. And then one would also have to have done a base cost valuation, correct, in March 2001 or October 2001, actually, for shares, property in a company, correct. So if the valuation rose, forgive me, I know it was 10 million, and if your shares in a property company and the shares were 10 million rand or more, you actually needed to do a valuation. And if you haven't, then you back limited to time apportionment or proceeds at 20%. So ask the client. SARS, the documents had to be lodged with SARS. I have tried in the past to ask SARS to give me those statements to see whether somebody has actually done. I see somebody in the chat has put goodwill at $1 million. That's right. Thanks, William. Correct. There was 10 million, 10 million, and 1 million, and maybe the 1 million was then the goodwill. But if you go back and have a look, you will find, you will certainly find the valuations on the SARS website. They've actually got an excellent section in the capital gains handbook for practitioners. So deemed assets, I said we could have a look under insurance and retirement assets. Then the big one with personal assets is to understand whether the person was married in community or property, out, with the accrual system, or by any customary religious laws. And also the other one was where they were married. I know there's a great example going around where a South African girl got married to a Dutch guy. They got married in Mauritius, but then stayed for a short point in time on honeymoon in Brazil, and then settled in the south of France. What was the marital regime? And normally they follow we're still on the old basis 9 times. Well, in all instances, we actually follow the man as far as who's got the trumping with a marital regime and the country. So again, ask the question, especially if you're dealing with families that were married in the UK. Those 9 times out of 10 are in community or property, and also within Zim, 9 times out of 10, those are in community or property. And then you want to understand the claim the spouse may or may not have when drafting the will. And also the other question in connection with marital regimes, and ask that question is, were any of you married before, and is there a divorce contract in place? I've seen it where a first wife has come out of the woodwork. I'm hearing that the ex is now passed, and she had a contract that basically said that on his death, she was entitled to one, in terms of the divorce settlement, she was entitled to one of the life insurance policies, regardless of who was the beneficiary nomination. And in fact, that one ended up being challenged. So again, ask the questions: have you been divorced? And are there any custody or alimony or palimony questions? Personal assets, again, from international laws, you've got to have a look at the law of contracts. And in some jurisdictions, trust is a complete look through. On the law of contract would be, let's say, for instance, an individual went into a partnership with and signed the partnership for, let's say, for instance, a bed and breakfast, and they did it while they were on holiday in the south of France, and it was for a villa in Italy and a villa in south of France. Which agreement actually trumps it, or which country rather trumps, and is any of that agreement or that asset as such an asset for South African estate planning purposes? And then the other one is, you'll see I've put it on a little bit of detail, forced airship. I'll deal with that just now. But situs assets, and I know probably, I think I want to say it was probably about 6 or 7 years ago, there was an excellent article circulating on situs assets, and it basically said that even if you have a share portfolio that's managed in the UK and it's got Microsoft and Apple shares, I want to say now probably Google and Facebook or any of the other shares in that portfolio, and because those companies are US companies and listed there as such, then there will be a death tax even though the person has never physically gone to the USA or the UK. So just have a look. I think the US, their rate is on a sliding scale up to 40%, and the UK is also quite onerous. And especially if there's immovable property as such, that's also taxed where the property is held abroad, and you'll need to defer to the double taxation as far as the estate duties are concerned. So situs tax, I want to say it's a minefield. I will give you one example where it was probably about 2 years ago, winding up an estate with a international bank, a well-known international bank. And as soon as we did transfer or send through the probate in the form of transfer of ownership, the individual then, or their compliance department came back and said, oh, hold on, we're entitled to a wealth tax on this. It was US based. And unfortunately, we ended up having to pay the tax on the asset offshore because of the nature of how it was held. So again, just unfortunately, planning nowadays, like we plan for global families, we actually plan for global jurisdictions as well. And it doesn't necessarily mean that your client is global. It could be that the nature of the investment or where it is held is then global. One that's often overlooked is exempt foreign assets. And if there was any foreign inheritance, that's exempt from a South African point of view. But once that foreign inheritance is received by the, let's say, for instance, the first heir, it's then neutralized and becomes dutable on the death of the heir. So here's an example. Pop inherits cash and investments from his mom, who was born and bred in Scotland, and she died there. On Pop's assets, these assets are excluded from the estate in his estate, but he bequeaths them equally to kid 1 and 2. Kid 2 dies, those foreign assets from Pop are then dutable in kid 2's estate. So just because it was a foreign asset, it unfortunately doesn't follow the conduit, and as soon as it becomes a neutralized asset as such, it will be subject to estate duty. Bearing in mind, though, foreign inheritance may, it doesn't need to be disclosed from a Reserve Bank point of view, but it's quite nice, especially because of all the KYC and the common reporting, to actually just regularize any inheritances that come in with your authorized dealer. And then just be cognizant or aware of the fact that although the foreign inheritance might not be subject to estate duty, South African estate duty, it still could be subject to South African income tax. So again, folks, you've got to have a look and see what is the jurisdiction? Where did you get it from? Have I got income tax? Have I got estate duty? And what is the nature of the ownership? And on the nature of the ownership, it's not foreign inheritance. The other one is then just pre-immigration assets. Assets held abroad prior to immigration to South Africa are exempt from SA estate duty. But important, there should be Reserve Bank or FinServ reporting and regulation at the time of the immigration, or that the individual used the 2001, or I think it was the 2018 Forex amnesties, where it was literally just regularized, reported. It may be because there was worldwide taxable income that needed to be taxed, but you could hold the assets offshore. Under the 2001 structure, if you held the assets offshore, it was fine. They weren't then subject to estate duty in South Africa. The 2018 ones, depending on what was the nature of the asset, it may or may not be subject to estate duty. I know you can still regularize by an authorized dealer for Reserve Bank purposes. Just check and ask on a no-names basis that there won't be any penalties or levies. I know Reserve Bank are quite happy to regularize, and I must be honest, I've never seen any penalties, and I've never ever seen one being declined either. And then also just have a look, because when somebody does, the woodwork that comes out of the worms that come out of the woodwork in connection with income tax, just see that if there's any pre-immigration assets or assets that are held offshore, whether there's any need to do a VDP for not previously reported income. And then the other one is forced airships. And you guys are going to be surprised to know that Mauritius actually has got forced airship, and look at it, because, and I certainly are quite, I want to say vocal, or I use Mauritius quite frequently as one of my planning jurisdictions, purely on the basis that it's actually easy to get to, and dealing with my colleagues in Mauritius now, they've come off the list, the grey list as such, but I understand their regulations are first world as far as their financial policies that they want to put in place, and it's actually quite easy to get to Mauritius. It's a close trip, but there's forced airship. So what is a forced airship? It basically means that the individual cannot freely dispose of their assets as they want to, and that very, very often happens with properties. Most European countries follow a civil law system, which differs significantly from the South African one. And again, you need to just see, you need to just have a look and see, with dealing with those forced airship, whether you can actually negate the forced airship in your will. Large parts of Latin American on that basis. And then the UAE, I actually went and the UAE is because you might find that people are on contract to Dubai or heading offshore. As we say, we've got this mobile workforce now at the moment. And I was very surprised on the UAE one that usually the structure goes that mom and the kids kind of share equally. On the UAE one, the in-laws, and so if, let's say, dad dies first, dad's parents and the kids get a bigger share than the wife does. So just have a look at the jurisdiction and just be cognizant and aware of that. I want to, I can't show if, I don't think I put it in here. It might be in my tricks and traps right at the end. Check when you do a will for an offshore, when you do an offshore will, that you don't have to sign at the consulate. Otherwise, it becomes null and void in the country in which you're going to issue and attend to the probate. And I'll give you Portugal as an example. Quite a few clients I know have bought properties in Portugal on the basis of getting the dual citizenship or the residency as such. and they bought the property, you've got to actually have a Portuguese will and it's got to be drafted in Portuguese, and it's got to have been signed at a Portuguese consulate in order to make it valid. Now, this one for me, the living L&D account, is probably the best and the easiest starting point when it comes to doing a will. Because you're living L&D, the way in which it's calculated or compiled as such, you actually put it together as if you were doing the final L&D account. And then you can sit with the asset and say, Dad says, let's say, for instance, I want to distribute my shares equally. And then you see that, well, actually, if we distribute it to one kid who's based offshore, what are the implications are we going to have? Or we might then have two kids offshore. Do we have any CFC issues? It also allows them to see that if they're giving one asset to one kid and another asset to another child, that the values are disproportionate once you take into account, let's say, for instance, the capital gain, because you might end up having an asset that's been held for a very long time. So you've got the dry cost in the form of the capital gain on death. And therefore, there's a disparity in value that the kids might be receiving as such. So it's a nice statement, sorry, not using the word nice. It's a great statement to use as a basis for a permanent file. Or it also, nowadays, you've got this electronic vault system as a client value add, and then you can use it to update on an annual basis, especially when signing off the annual tax return and the accounting compliance requirements, and just update it. And whether you keep it at cost or base, cost or market value, etc., it doesn't really matter. But it's the fact that you are recording. Ideally, if you're doing the L&D account, you do want to do it at market value, because that then gives your client an example of what the estate's going to look like in the event of his death. Folks, I see there's a question just popped up. When redistribution agreements are drawn up, is it only the assets excluding the liabilities? Again, Rose, that just depends on how on how the redistribution goes. So let's say, for instance, it's an immovable property and there's an attendant bond to it, then you're not going to give the liability to one heir and the asset to another. You might find then that the assets follow, because bearing in mind a redistribution agreement doesn't necessarily have to be equal value. It could be a redistribution of assets. So let's say, for instance, you could have one child that is offshore and doesn't really want the beach house, but there's a share portfolio. So you'll enter into a redistribution agreement where it's basically I could get the property that's got a lesser value than the share portfolio, and in lieu for that, there's a portion of cash or whatever that's paid. So to answer your question, it depends, Rose, on a case-by-case basis as to whether there's a liability that's attached to that attendant asset. And again, be really, really careful, and that you need to check when you, in the event of divorce and or the event of death, is hidden capital gains tax, a dry tax. So be careful if you're distributing an asset to somebody, there could always still be a capital gain ultimately on the liquidation of the investment, or actually on transfer that you don't necessarily pick up on the L&D account. Kalika, see you've got one. High foreign assets regularized at the time of 2003 amnesty. Are these foreign assets subject to state duty? Kalik, the answer is, again, it depends on how those assets were received at that point in time. If it was a foreign asset that was from while working abroad or from an inheritance, the answer is then no. If it was foreign assets that were taken out kind of illegally, because that was the the sport at that point in time to take it out, then you could end up having those assets subject to estate duty in South Africa, because technically those were South African assets. So I know I'm not answering your question, but the answer is it just depends on the nature of the asset. So sorry, folks, let me, oh no, sorry, just give me a minute. Oh, sorry, folks, I am challenged here. I don't want to record it. Sorry, just give me a minute. I want to get back from the current. There we are. You can see I'm absolutely useless with IT, so I apologize up front. Okay, so how is the estate duty calculated? And this is quite a nice way to sit down and show your clients and have a look whether there's actually any cash shortage or liquidity issues in your estate, and whether there's a need for any planning accordingly. So essentially, it's your worldwide assets, less your liabilities, and again, it's your worldwide liabilities, including the capital gain on death, income tax, executors' fees, deathbed and funeral expenses, and other permissible costs. In connection with the deathbed and the funeral expenses, I put an asterisk because if at the end of the day, your will doesn't say that if any family member has to fly from anywhere in the world to get to your funeral, you can't claim those expenses in the L&D account. They're not deductible as such. So if you have got kids, if you're doing the plan for somebody who's got kids overseas, and on the death of the individual, funds will be made available from whatever South African source to get that offshore child back to South Africa. If you've got in your will, and obviously it's not people flying first class or business class, there is a limit and it does get reviewed, but you can certainly claim certain funeral and deathbed and travel costs for estate duty purposes. So that you get your gross value of estate, plus then you add deemed assets, and we'll go through deemed assets just now. There's bequest to surviving spouse, and remember that your section 4Q allowance is anything that goes to a surviving spouse is exempt from estate duty. Less your offshore inheritance or pre-immigration assets, they come off. Less any deemed asset paid to a spouse. Now, just on the deemed asset paid to a spouse, if a deemed asset, there might be an instance where, let's say, for instance, you've got, and I'm sorry, I'm dealing with deemed assets like a policy document that gets paid to the estate. It might, or like, for instance, a pension. It might be not dutiable because there's an income tax, but there could be your executors' fees on it. So again, just have a look at what assets are you including in your estate as such, because that then makes them estate, well, they will become estate duty regardless of whether they go into the will, but executors' fees could be paid on that. And then it's the 3.5 million abatement or the unused portion from a predeceased spouse's estate. Now, in logic will say if your spouse died and you used the 1 million and that was the permissible abatement at that stage, you haven't got the 2.5 million. The answer is you've actually got the 2.5 million and claim it. I haven't yet seen any instances where SARS have disallowed it. So if at the end of the day, when your individual died, the abatement was, I think it was 1.5 million a few years back, and you claimed the 1.5 million, you can certainly claim another 2 million in the survivor's estate now. That gives you your dutiable portion. Any amount less than 30 million is taxed at 20%, and over 30 million is taxed at 25%. A big one, folks, and especially because of delays that are happening because of at the master's office or just winding up nowadays, estate duty has to be paid the earlier of either one day from the date of death or on SARS assessment. I'm finding now at the moment, few estates are actually wound up within the year, so you've then got to make a payment for estate duty. What is that payment? It needs to be a fairly sized, a big portion of the estate. I've got estate now at the moment where we're paying 4.6 million rand. I'm a year behind, so we've just paid the 4 million, and I've managed to get deferment on the 600,000 because we're just waiting for valuations. And again, SARS are very accommodating. You deal directly with the estate duty unit and apply for extension, or apply for a position where you're going to pay only a percentage of the estate because you're still waiting for figures, or it took a while to get a real live one now at the moment. That example that I'm giving you, where I've got mum and dad who died within 4 months of each other, we're battling to change letters of executorship. So I'm sitting now going on, dad died in April, it's now November, and I'm still waiting for revised letters of executorship, and I can do nothing about it. So I'm going to hit the April before I've wound up most of the estate, but then I'm going to have to pay estate duty. So just bear that in mind. Otherwise, there are hefty penalties and interest. Looking at the question, Khalik, following on the amnesty question, if the assets were regularized by the BDP process and the assets were offshore assets received by inheritance and regularized in 2015, if they were received by an offshore inheritance, I'm going to go with my answer to that was no, they shouldn't be, because it's regularized and they were from an offshore inheritance. Hope that answers your question. Then, in connection with the L&D account, what is the outputs that you get from it? It's basically a real-time snapshot of what the will would look like when it's executed on the death of the individual. And it's a great estate planning technique because you can look at the liquidity within the estate, you can look at the cash flow, cash shortfalls, and any dry taxes and estate duty and capital gains on death and executors' fees is a dry tax if you've got, let's say, for instance, an immovable property. And again, dealing with an example, mum died. The only asset that she has is the family beach house. It's now being bequeathed to the 2 kids. Mum's got nothing else, but because it's going to the 2 kids, we've got estate duty, we've got capital gains tax, and technically there'll be executors' fees. So it's an immovable property where you're getting the liquidity from. So think about it when you put in and doing the plan. Then wills. You'll see I put will and wills in inverted commas. I've had the question, I've had the question being asked as, if I've got a property in, let's say, for instance, the UK and Portugal, do I need a UK will and a Portuguese will? The answer is not yes. You might find that because of Portuguese forced heirship, you'll have a Portuguese will that will also deal with the UK property. So you don't need to have a will per jurisdiction. I've seen it. You don't need it. You need a will that either deals with worldwide assets and then choose a place in which you're going to do probate. And remember, from a probate point of view, you can choose somebody in the UK that then can deal with probate in Europe, or if you've got family members or assets in the States, you can get somebody there to wind up as such, and they can deal with assets on a worldwide basis. What is the reason for having a worldwide will, other than jurisdiction and other than forced heirship as such? Folks, it's purely for ease of convenience. At the end of the day, quite often you find if you've got immovable property, they want court sealed documents. to get court sealed documents nowadays, it used to be quite quick. You could get it within 4 to 6 weeks. In some instances, I know it's taken up 6 months to get court sealed documents. So nothing can happen from a probate perspective offshore until such time as the local will has been court sealed as such and sent abroad. So if you find that you run in an offshore share portfolio and you do want, your client would want somebody to continue to, or for it to be wound up timeously so that you can continue to administer as such, then create that foreign will. So often I've been asked the question, is it a must have? The answer is no. It is a really good cherry on the top, nice to have, and depending on your jurisdictions, and obviously cost, because remember probate will also cost offshore. So just because it's and that's another one that people then think that if I've got a local will and an offshore will, then my offshore assets won't be included in my local L&D account. Wrong. Those assets are still included in the account, they're just not administered in South Africa. So again, that's a misconception that if you've got a foreign will, then you don't need to reflect or record any of those assets in your South African L&D account. For me, really, I tend to definitely do a worldwide will if I've got immovable property, just purely because dealing with the conveyance or the transfer attorneys offshore is a whole lot easier with a local will or a local probate officer than it is dealing from a South African perspective. The other one I want to say is from an output with regard to the estate plan, have a look at your beneficiary nomination forms. Life insurance, not key man assurance and buy and sell policies, as the benefit doesn't accrue to the owner of the policy and not the deceased. So you don't necessarily need to worry about your beneficiary nomination forms for life assurance, but make sure that for your normal life, you've got that beneficiary nomination form is up to date. Disability cover, there's very, very seldom is there a fund value on death, but there could be, check that. And then obviously all your retirement products and endowment policies, check who the beneficiary nomination is. With regards to retirement fund products, the trustees have the discretion as to if there's multiple beneficiaries as such, or multiple, not beneficiaries, dependents. I think it's Section 36 of the Pension Funds Act, they can change your beneficiary nomination. So let's say, for instance, mom does put, let's use the famous pool guy as the beneficiary nomination, but she's also been supporting her dad, and she's still got little Johnny who's still dependent on her because he's only in third year varsity. The pool man is not necessarily going to get the pension product. If mum can prove that she has been receiving a benefit and support, and certainly little Johnny can prove that he is dependent on mum still financially, the trustees on retirement products will look at who the beneficiary is or the dependent and make payment as such. And sometimes if there's no clear cut as to who a dependent is, they will actually wait almost a year before they make any distributions or any awards, just to make sure that, again, you don't have any children coming out of the woodwork or dependents. And you normally find that only in very seldom occasions does a pension fund pay to an estate. 9 times out of 10, I've always seen it go to a dependent. And I want to say the trustees they obviously have a fiduciary responsibility, so there's a fair amount of due diligence in with who becomes a dependent. Also, you'll see I put it in the tricks and traps at the end, and it was something that I didn't know about and learned about 3 years ago, that if you've got a minor child reflected as a beneficiary on an endowment policy, on the death of the owner of that policy, that endowment actually gets paid to the minor or to the guardian. So if you're planning to think that at the end of the day, you've got these endowment policies, and often endowment policies are set up for education needs, and then you put the child as the beneficiary. If you predecease and the child is still a minor at the time of death, the policy actually gets paid to the child. So you can end up, and I've seen a real life example with a 10-year-old and an endowment payout of about 12 million. And you want to see the amount of PlayStations or what this kid thought he was going to get in the form of PlayStation. So again, just be careful and ask those questions. I've got a 2-minute. The father passed on in 2003, 1 million claim. Mother died in 2010. How much can be claimed for mum? So the mum will get the 3.5, plus they will get the 2 million from what the dad claimed. So you would claim 5.5 million on that one, Kalik. And Renee, you've asked issues in connection with a joint will. Yeah, it's a good question. I am opposed to joint will, not because of the technical issues, because of the hassle nowadays that on the death of the first dying, remember the original will has to be lodged at the master's office. And given the challenges and the complexities of getting just everyday documents from the master, if dad or the first dying died a couple of years back and now you've got to go and get that joint will. Yes, Renee, I'm a betting person, and I certainly wouldn't bet on finding that joint will out of the master's office. And you know what also I've seen happen is family members then forget that there was a joint will, because let's say, for instance, the first died a number of years back, and then they search for a will, can't find one, and then assume that mum or the last died intestate. So joint wills are great, especially if the person is married in community of property, and it's an easy way in which to manage and deal with it. Practically, I wouldn't trust the original will at the master's office. And I'm very sorry to say that if there's any master's people here, and it's for no reason other than just the challenges you master staff are challenged with regards to your filing systems. So it's more of a practical issue, Renee. And I see there's a chat one. Question off topic. If I inherit my father's credit loan account, say 10 million, then do I pay deemed nationals tax on the loan, given there was interest-free loan now owing to me? If I inherit, let me just put that. If I inherit my father's credit loan account, then do I pay deemed? No, I'm understanding it's a trust, or even with, I want to say, yes, you would. Well, you would then, because the nature of that would then, it's an, yeah, actually, William, I'm actually going to take a snapshot of that. You've got me stumped there. My gut feel says yes, you will, because at the end of the day, you now become the credit holder. In other words, it's a debit loan account owed to you by the trust and or a company. So we want to say, from a taxing point of view, the answer is yes. But can I come back to you on that one, William? I can't answer it with that amount of conviction or confidence. And those, I think, are the questions. All right. Oh, no, I can't get out of this.
Cheryl, it's now 2:30. Do you want to take a break and just sort?
Yeah, sure, folks. If you want to take a 2-minute breather, or Danny, we're in your hands with regards to.
Should we take a 5-minute and restart at 2:30?
Perfect. Perfect. I'm just getting back to where I am and start from current slide. Okay, I'm back. That's perfect. Happy. All right. See you all in 5. Bye. right.
I hope everyone's getting ready to start again. Cheryl, there is another comment in the chat section if you want to have a look at that.
Okay, let me have a quick squeeze. Sorry. In respect of income generating assets such as rental property investments, between the date of death and the distribution of the assets, does the income accrue to the estate or the beneficiary? Okay, that depends on when the person died, and for estates after, it's now 2017. All right, so is everybody back? So whereas in connection with this one, it depends on when the individual died. Over the last, since 2017, any estate after that, you've got to register a deceased person, and you essentially do your deceased person up until the date of death, and then you've got to register a deceased estate. And it is the same tax number. In the old days, if you remember, if there was a capital gains, you had to register a special trust. All of that's fallen away. And then all the income accrues to the estate. It's paid in the estate. And only once the estate is finalized and distributed does the asset go to the beneficiary, and then the income accrues to the beneficiary. So just check when the person died or which estate you are winding up, because that was often SARS, or the reason that it got changed is that technically the income started to accrue to the asset from the time of the individual's death, but very seldom did the executor then tell the heir or beneficiary or legatee what the income was, and then it was never disclosed, and then they received this asset, and then they had to go back and open a whole lot of prior year returns and add the income. So there's been a whole change in the SARS system, and I do want to give kudos to and credit to SARS. Well done. Their deceased estate functionality and system, superb people, and the team that look after the deceased estates, other than Shan, the one Oka does all the valuations, SARS deceased estates is actually very good at this at the moment. Right, welcome back. Let's have a look. Now, I'm not going to go and Danny, I want to say this is a sales thing on this side. Trusts in itself is another whole 3 hours. So I'm not going to go into the details from a trust perspective and what you can and can't do and the taxing of a trust, etc. I'm looking at it purely from an estate perspective. Just quickly, by the way, William, I during the break, I quickly had a look, and yes, it would seem that if you receive that asset, the taxing mechanisms that were in place, you would then continue to be taxed as such. So if it's a credit loan account as such, so in other words, the trust, in other words, sorry, the trust is owned to you, 7C would then kick in, or if it's a debit loan account, the other way around, sorry, forgive me, the debits and the credits. If you've then got a debit loan account from a company as a deemed dividend and you inherit that debit loan account, so it's asset in your individual estate, then you will still have the deemed dividend tax apply to it. The other one, and it was quite a complex one to put in, but it's something that I do want to say is relevant, is that if you've got trusts, you're finding that nowadays people are almost unwinding the trust structure in order to remit the funds abroad. And I've seen so many instances where the funds are actually loaned to the beneficiaries who then take them offshore. Then you sit with a situation that you've got no South African assets other than this loan and indebtedness that you owe the trust, and that's then matched by an offshore asset, whether it's an offshore investment or whether you've created an offshore trust. A big one, folks, is to actually marry the one asset. So if you're going to bequeath it to your kids, you say, I've got an indebtedness that I have to my South African trust in the extent of 10 million, but coupled with that, I'm owed 10 million by my offshore trust. So you can get the offshore asset provided you take on the indebtedness. And what one does, just to make sure that all parties are involved, because remember, the trustees, you can't, in terms of a will or even a letter of wishes, you cannot give direction to your trustees, otherwise it becomes a sham trust. Do an agreement and get your offshore trustees and your local trustees to agree with the structure. And I've actually had a case tested through from a SARS perspective, and it passed, where at the end of the day, we matched the South African liability with the offshore asset, and we're allowed to distribute the combined asset to the South African beneficiaries. Right, looking at trusts. I am a total fan of trusts if they're used for the right reasons. Basically, a trust is a vehicle. It's a legal persona for tax, but not for any contract or litigation. Remember, it's the trustees who are then actually own the assets, which is formed by a founder or a donor for the benefit of beneficiaries, and the assets of which are administered by the trustees. Now, there's also you need to just distinguish between what is a founder, a donor, and a funder, because you could be the funder of a trust, the founder of a trust, but not necessarily the funder. And as the funder, you could then be trapped within Section 7C. So just remember which hat the individual's wearing. From a funding of a trust by, and I've put in there, a founder, a donor, or a funder, because those are the words used interchangeably nowadays. It can either go on loan account. If it goes on loan account, that's still an asset in the individual's hand. It can be an outright sale, provided the trust is an established trust and it's got cash, and therefore the individual will have cash back in his hands. Or it could be a donation where donations tax being paid, and that basically strips the asset completely out of the individual's hands. I was listening to somebody the other day on a planning perspective, and they said, do the structuring from a donations point of view because it's cheaper at 20%. Folks, donations tax follows exactly the same as estate duty. So any donation under 30 million is at 20%. Any donation over 30 million is at 25%. So be careful you don't get trapped by thinking that you can make a donation and save the estate duty. Or it could be a combination of any of the above. I've touched on very briefly here why form a trust in form of an estate planning. Now remember, I'm assuming in our estate planning that most of the stuff is set up. You might be in an instance where somebody comes to you and says, I want to set up a trust. Why do you form it? For me, the biggest one is limited liability and protection of assets from creditors. And take that assets or the creditors is quite broad. It doesn't include your exes or it could include your exes and in-laws as such, or the proverbial outlaws. It's for me that at the end of the day is is your main reason for setting up trusts. But don't set up a trust per asset or per asset class as such. You can still have one holding trust provided your trust is administered correctly and you've got your independent trustee and there's proper records to show that trustees have exercised their discretion, decisions have been made, whether it's unanimously or by majority vote, you really only need one trust. And I will be honest, when I started to do financial planning in the 80s, at that point in time, our structures then were trusts with a company. The reason that we had the company in those days was because there was preference shares and there wasn't too much case law on trustee responsibility or alter ego control, and therefore you set up the trust with the trust and then the company structure, and you essentially gave the preference shareholder or the B class shareholder controlling or voting rights, but no valuation rights. Nowadays, I want to say, given and I will say the uncertainty or SARS's dislike for trusts, we're back into the case of setting up the trust and the company structure. So it's almost in 30 years, the wheels turned, we're back to where we started. And I think a trust and company structure is a very neat and tidy way in managing one's affairs. Just be careful that ultimately, when you come to unwind the company, understand the exit taxes. So again, folks, coming back to doing any estate plan or any planning along the way, whether it's tax planning, estate planning, or financial planning, always look at, always ask the question, what happens if I have to unwind the structure? Who's it going to affect? What is it going to cost? And what happens with those assets? Other reasons for forming trusts is if you've got maintenance of minors or maintenance of other persons or incapacitated people. In those instances, you might find that you've got a special trust, and special trusts have got same taxing rights as individuals other than the primary rebate, but you're on the sliding scale. Otherwise, all trusts are taxed at a flat rate of 45%, and your inclusion rate is 80% of your capital gain. So yes, trusts are punitive from a tax point of view. So nowadays, I think very few people set up trusts from a tax planning perspective. Big one is the continuity of family wealth and succession planning. And then a really good one is the consolidation of family wealth. If at the end of the day, you have one portfolio of, let's say, for instance, 40 million, you can do a whole lot more. A portfolio manager can A, negotiate fees, and B, you can do a whole lot more sexy things with the 40 million rand portfolio than you can, let's say, for instance, if you had to then distribute that portfolio on the death of mom and dad 3 or 4 ways, you tend to find that there's a dispersion then at that stage, and you lose value. At this point in time, I also want to put in my comment in continuity of family wealth and succession planning. At a meeting I had, a breakfast meeting this morning, the client was asking, or the individual was asking about offshore trusts and when to set them up. Offshore trusts are hella expensive to manage and administer. If anybody knows, you just have to send an email to them, and the amount of KYC and FICA and all their risk compliance, and with that comes a hefty bill that's either euro, pound, or dollar denominated. So you do want to amass a fairly good base before you create that offshore trust. And something that I'm used quite frequently, and I think is a great planning mechanism, is what we call the bottom drawer trust. And a bottom drawer trust is literally an inter vivas trust that is set up offshore. It's administered and run, it's dormant until such time as the death of either the first or the last dying spouse, and then those assets are then transferred into the offshore trust, given that at that point in time, either you want to protect the assets and keep the offshore assets, protect them from creditors, and do the consolidation of family wealth, and keep them out of the South African beneficiaries' estate as such. You then, this bottom trust is then triggered and gets it's capitalized as such. So it's formed, but it just remains dormant. And again, I've used Mauritius quite frequently for bottom drawer trusts, and you'll find that there's some trust companies that offer very competitive rates for bottom drawer trust, which is an inter vivos trust, but only kicks in on the death. It's not a testamentary trust. It only kicks in and becomes capitalized. When you're looking at a trust from a documentation, and I'm really only dealing with an inter vivos trust, remember a testamentary trust, you could still have all the other documentation, but you won't have a trust deed because your trust deed is the will. As soon as there's a testamentary trust that's created, part of my annexures to my will are almost a inter vivos trust deed. I give all the powers and responsibilities and the duties of trustees that you would give in terms of an inter vivos trust. I actually put it in as a testamentary trust. And I know there's a hell of a lot of pages then that need to be signed and scanned and witnessed, etc. But the devil's always in the details. So if you can put in as much detail and give your executors and your trustees on death as many powers as you think they would need to administer assets going forward, then there's the fact that there's extra documents, it's fine, suck it up, sign the documents. Resolutions and trustee minutes, make sure they're in. As soon as you've had your meeting, send those trustee minutes, send the resolution. Resolution, you can put in the clause at the bottom that says that this resolution can be round robin and signed separately, but collectively make one. So especially because you might have people all over the place, get your resolution signed, make sure there's loan agreements, make sure there's deed of donation agreements in place. And then I want to, and this kind of sounds like, and I'm standing on a soapbox on this one, those letter of wishes that we see where it says, please keep my family in the method, in the lifestyle to which they become accustomed to or they currently have during my lifetime. Yes, that's a horrible one at times, on the basis that, let's say, for instance, dad dies early and leaves mom with a really sizable estate, and now the custom to which they become, or the lifestyle to which they became accustomed to, was to only have one annual overseas holiday when dad could take time off from work. Now mom's got all the bucks in the world, the kids have flocked the nest as such, she's got empty nest syndrome, and now the trustees are saying, well, actually you can only have one annual holiday. So then my advice or my recommendation or my answer to that one was, in fact, well, then take one holiday from the 1st of January to the 31st of December. We're still taking one holiday. So I want you to have a look at or use that example that I've given at the end of the presentation. And I'm quite happy. In fact, somebody asked me when I posted it the other day as part of another documentation pack, they said, oh, but now you're giving away your IP. It's not giving away my IP. The more people and the more professionals who can actually provide good, sound professional advice and keep the clients, give the best interest for the clients, I want to say I'm happy to share. And if anybody wants to ask any questions about it and whatever, give as much detail as you can. In some of my letter of wishes or my policy statements, I've actually given a description of why decisions are made in connection with the family members, and put in the family tree and done the introduction with the family tree, especially if you're doing a letter of wishes for an offshore trust. I want to say on an offshore trust, the offshore trustee probably actually only gets to meet the planner once a year. And it's then usually fairly formal when they come out to South Africa and they do the work as such, and it's usually followed by a lunch. And if there's followed by a lunch, you get to chat about the rugby and the cricket, but you don't, again, coming back to what my very first slide was, ask questions and get to know your client. So to give a policy statement to your offshore trustees, hold on, let me say, it's not a policy statement to your offshore trustees because you cannot give any, you can't give any instruction to anybody. So it's not a policy statement for offshore trusts. It's a letter of wishes. It's a detailed letter of wishes, and it tells your trustee, this is the money that you're managing on my behalf. These are the players within my family. Now, these are the things I would like you to consider when administering the assets. So folks, that one page, or it's about 2 pages, because I've seen them copy and paste so many times where I've actually also even seen they've used the wrong individuals or wrong people's names within the document because it's cut and paste. When you come to do that letter of wishes, I know Arnold Shapiro, and for me, I think Arnold Shapiro, along with a good friend of mine, Trevor McGlashan, the two of them are doyens as far as wills and trust administration is concerned, and deceased estate administration. And Arnold always says a will is a legacy of love. You actually want to leave this document that it gets wound up at the end of the day and all of your beneficiaries are happy, and you're not sitting in any situation where there's any boxing because nobody is unhappy as to the decisions you've made. And likewise, in connection with your letter of wishes and policy statement, give as much detail as you want to. And then obviously other supporting contracts and agreements. Taxation of trust, as I said, I'm not going to go through that in detail. It's usually taxed within the trust if it's not attributed and vested. Attributed and distributed and vested have got 3 different connotations, and your accounting for distributed and vested is very different to attributed. Attributed, quickly folks, it doesn't hit the balance sheet of the trust. It's literally just taxed in the individual, the founder or the funder's hands, the donor's hands. There's no accounting entry in your trust. Distributed or vested, it gets taxed, it gets disclosed on your financial statements. And then just remember, any vested income is not included in your Section 7 taxing provisions. Vested income is excluded if it's paid on loan account. Like I said, trusts are taxed at a punitive rate of 45% with no flat rate from the first R1 with no rebates. You've got your Section 7 deeming provisions and attribution, and then your now your Section 7C for low interest free or non-market related loan accounts and interest free loan accounts. And then just with regards to distributions to beneficiaries, you've got your 25B. Taxation of trust, again, I've just quickly touched on 7C. Loan for primary residence is excluded, and accumulation of vested benefits on loan account is excluded. Then a big one is your conduit principle, and it needs to be in the year of assessment that the income retains its identity when it's vested or attributed or distributed to a beneficiary. So if it comes in as interest, it goes out as interest. Likewise, if it comes in as rent, it goes out as rent. The only one that you cannot do is if it comes in as a capital loss or it comes in as a trade loss or a loss, unfortunately, those losses stay within the trust. And then a big one, if you've got private companies or companies, there will be dividend withholding tax paid on the dividends received, because remember, your ultimate beneficial owner is individuals, and there's also no donations tax and awards made to beneficiaries. And also an important one, and this I was advising recently in connection with it, where we want to unbundle a property out of the trust, and we've missed that amnesty from a few years back. There is no transfer duty if the property is awarded to a beneficiary. There's still capital gains tax, there's still conveyancing, but there's an exclusion for transfer duty. So that's also quite a nice planning technique. If you do want to unbundle it, you don't necessarily have all the dry taxes. So that in itself, although trust assets form part of an estate plan, Your planner has got absolutely no discretion whatsoever on any of the assets that are held in the trust, even though he or she might be the founder, a trustee, and a beneficiary. Those are trust assets. They belong to the trust. Your will should never, and I don't put it in my wills. I do it as a resolution to say that on my death, I would like so-and-so to become the beneficiary, to become the trustee in my place. That's not your will, or it's not for you as a testatrix or testator to determine who is that. You've got to leave that to your trustees, and rather do a failing trustee resolution where it says that on the death of so-and-so, please consider the following person to be nominated as a trustee. And likewise, I've seen agendas go out, and I know me and my team were guilty of it at one stage, because we used the agenda as we were also doing the beneficiaries' income tax was review of will. Do not do your review of will under your agenda when you come to doing trusts. So as I say, other than for the loan account, and if you've got a vested benefit, just be careful with that vested benefit. I know the reason that vested benefits are created is because you want an income tax split amongst a number of beneficiaries. And then what happens is, especially if you sit with this capital gain of a massive capital gain, and you vest it to your beneficiaries, and you think, oh, this is great, I've now saved myself tax. I'm having a tax at the marginal rate of 18% as opposed to 36% if I kept it in the trust. But then just remember, little Johnny's actually got a right, and in the event of little Johnny going insolvent, or little Johnny dies, trustees need to pay that money to Johnny's estate. And there is case law in connection with that. Again, with an individual that went insolvent, and the trustees tried to argue to say that that asset was not his, it was vested income, still to be paid at the discretion of the trustees. Even though it's paid at the discretion of the trustees, it's still an asset in Johnny's estate. So you could find that you're winding up, or you're unwinding the good of protecting the assets by actually distributing, or not distributing, vesting income to beneficiaries and having a tax in their returns. Ultimately, you're going to be in a position where somehow you've got to pay this. And I'll give you, I actually sat this morning because I've got a meeting at 12 o'clock tomorrow, and I can see my beneficiaries are going to bleat, my son and daughter, when they see how much vested capital gain over the last 23 years has been, or how much vested income, 2001, I suppose it is almost 20 odd years, how much money's gone to grandchildren. And here these kids think they're going to get, we're unwinding the trust for specific reasons, and the son and daughter are going to think they're going to get a large chunk. Well, I did the calculation this morning, and they're going to lose probably about 40% of what they thought was their inheritance, because we've got these vested distributions to grandchildren, and we're going to need to pay the grandchildren out. So just look at from a estate planning perspective. If you put the structure in place, go back to the basics. Why was it put in place? What were you protecting, and what was your aim? What if you're doing something now from a tax planning perspective, or from let's say maybe circumstances have changed? Is your objective still the same? And what is the consequences of unwinding or doing anything in connection with it? I see we've got a quick question there. Contra principle, does it apply to dividend as well as the dividend should be distributed in the same year to retain the dividend data? Khalid, yes, it does. Remember, your dividend is tax-free, but the answer is yes. Any income that comes in retains its conduit principle as it goes out, whether it's a capital gain, REIT income, and you'll see now in the tax returns, when you complete the SARS e-filing with it, it said, did you receive any benefit in terms of a 7C or any distribution or vesting or attribution from a trust? If you tick yes, then it asks you how many trusts, and then you've got to put the trust name, you've got to put the trust reference number, you've got to put the trust tax number, and then you actually get the full-on schedule with 3601 remuneration, foreign remuneration, dividends. It's literally all your income categories are then reflected. So SARS, you can't just say there was a distribution of X amount. When you complete the individual beneficiaries return, you have to reflect the identity of each of those awards as such. I hope that answers your question. I also want to say the other thing that you need to be cognizant and aware of when you're doing the vestings and all the distributions and attributions, if you've got taxable and non-taxable income, any of your trustees' fees or accounting fees, any general expense as such, needs to be split between taxable and non-taxable, and then you can only claim the proportionate, in those proportions. And SARS, I have been queried on that. SARS do ask that. And be careful as well. I remember I was on the panel a while back when we were re-looking and revisiting the income tax return for trusts, and one of the questions was, does the beneficiary have access to the trust or live in the trust property rent-free? And everybody thought, oh, watch this, they're going to introduce fringe benefits. It had nothing to do with fringe benefits, but everything to do with what were the expenses that you were claiming, and was there an issue with expenses? That's your one, Khalik, I think. Yep, I've answered that one. So that's trust, folks. They are a really good estate planning technique. They've got great for protection of assets, just use them in the right place. Then building block number 4, we look at companies and closed corporations and share blocks. And then you need to then see whether it's held by the individual, then it's dealt with under building block 1. So in other words, it's a personal asset. If it's held by the trust, then you deal with it under block 2, and then you may or may not have to deal with it. And then if it's held by another company, look at where the whole holding company ownership is determined, whether it's dealt with in block 1 or 2. Just quickly then, as I say, on the CRPC basis, and that's this horrible one where we're dealing with these 4 properties between the two CCs, the company and the individual. When you come to do this, just do a CRPC search. I know it doesn't necessarily show shareholding. Well, not necessarily, it doesn't show shareholding, but it certainly shows directorships and memberships. And then because there's a directorship or membership that's popped up, you can then ask the question, if a person is the director of a company, then is there a shareholding? So that way you don't get caught blind when you start winding up the estate and then you start going through the boxes and then you come across old company documents. Where the planner is the sole director, have a look at your succession planning on the death of failing a director. And that, folks, happens so often in investment companies and or property owning companies, or even the family business. Sit down, and when you put in the will together, ask, are you a director of a company? Yes. Sole director? Yes. Who do you want as your succession planner? It doesn't necessarily mean that that person's got to be appointed via CRPC, but then make sure that you know who that person is. Again, I wouldn't suggest that you do that within the will, rather have a separate individual document in connection with that. There was also, in connection with your will, if you have got, this is just I want to say it's more planning or practical than anything else. Remember, you're not going to appoint your directors or your trustees in your will. You are going to appoint a guardian. And if you appoint a guardian, please tell your guardian that you're appointing them and they're now going to be the happy, proud owners of 2 or 3 kids that aren't theirs as such. Talk to the people who you're appointing. I have sat, and I know there's been movies that are made about it, and it's a real bugger when you sit at a table and you start reading the will. And I've been in 2 of those reading wills where you where it's almost like a Charles Dickens situation, and then you say, oh, and so is appointed the guardian of the child, and this is the spinster daughter, the spinster sister, and it's come at a shock. It's funny later on, but when you're sitting with it, yes, it's horrible. Let's just quickly look at questions. Can a trust deed include the clause referring to alternative trustees? Yes, it can. Deal with alternative trustees in a resolution rather than within the trust deed. Because remember, if you've got the document in the trust deed, then every time you want to make changes fundamentally, then you've got to change your trust deed. Where if you deal with it in a trustee resolution, it's easier to manage and change. And if so, who in terms of the Trust Property Control Act can act on behalf of the trustee, and in which instances can it be appropriate for an alternative? So just remember, an alternative trustee, just because you might have somebody who's coming in as alternative, you've still got you don't stop your fiduciary responsibilities happening. And again, the Trust Property Control Act doesn't give guidance as to who the person is. It basically just says a trustee must be a responsible person, and as if you were dealing with your own monies as such. So you just need to make sure that the nomination is a sound person. But I would rather deal with it in a resolution. And I'll give you an example. And if anybody wants it, I'm happy to share. But I basically have a resolution, and I review it once a year when we sign the financial statements that says, in terms of clause X, there's a minimum number of trustees. On the death of trustee 1, please consider so-and-so. On the death of trustee 2, consider so-and-so. In the event of 1 and 2 dying together, appoint all of them, or bring in the kids, or whatever the case is. So do it as a resolution. Have you discussed living annuities and the effect on estate planning? No, because I'm going to do that, Shah, in deed assets. And then Kalik, if the dividends have been retained in the trust as accumulated funds with the intention to distribute in the future, is it still distributed as a dividend? The answer is no. It's then distributed as retained income, non-taxable as such. Because let's just quickly, Kalik, use your example. If interest came in and it wasn't distributed or vested at that point in time, then it would be taxed in the trust, and then it becomes retained income. Then when you distribute it the next year, it has been taxed, so it's not going to be taxed again, and you're essentially distributing retained income. So retained income would have been taxed, or it would be tax-free if it was a dividend, and therefore when you onward distribute or vest it the next year, it then goes as retained income. Shah, in connection with your living annuities, we'll touch on it then in the deemed assets. Right. Then building blocks, then why use a corporate structure? It's done if there's multiple shareholders, such as holiday properties or trading investment companies, if it's a family-owned business, if it's limited liability, you want to protect limited liability, and you might not want to put that particular asset within the trust, then rather put that asset within a company with the shares held by the trust. If something that happens within the company, and again, I say provided there's been proper care, so in other words, there's not been any reckless trading, you've still got the limited liability. A shareholder's technically never been challenged on a limited liability. It usually happens down in your underlying corporate structure. You might have outward bound investments using a foreign direct investment, and now you can use up to 1 billion rand. There's that facility, or there's inward bound investment, and that's with the so-called loop structure being relaxed. And then the other one, and again, I'm going to get on the soapbox with this. I want to say it's the capital gain and the income tax rate. The individual inclusion rate for capital gains is 40%. It's 80% for trusts and companies. At some point in time, that 80% is going to, that 40% is going to move to 80%, plus also your income tax rates. And you've seen now this year we've had a decrease in corporate rate. So I'm not advocating tax avoidance or evasion. It's a planning opportunity, and there might be a good reason to literally put an asset within a company. And in fact, I'll tell you what the reason. I'm actually answering part of my own here again. It comes back to, if you're going to tax plan and you're going to do the vestings to all the multiple beneficiaries in the trust, you might still hit, let's say, for instance, an effective tax rate of 27 or 28% for your individual beneficiaries. But what have you done? You've put that capital back into your beneficiaries' hands. It's not within your structure. So why not use a company? Pay your company rates for income tax, pay your capital gain rates for the 22% for your capital gain. Just remember, the only thing is, if you do have to take monies out, then you are going to have to pay dividend withholding tax, because it will ultimately go from the company to the trust to the individual beneficiary. But if it's a case of pegging capital gain and income tax rates, why not use a corporate structure? In your corporate structure, now with the introduction of the memorandum of incorporation, as opposed to the old articles of association and old documents, in the old documents, you had the M&A and then you had a shareholder agreement. Now it's replaced by your MOI. So just make sure that if at the end of the day you do have a shareholder agreement, it's not in conflict with your MOI, and you then undo whatever you have within the shareholder agreement. Details within your shareholder agreement, I don't necessarily call it a shareholder agreement. It might often be a policy understanding where you've got two family members or two individuals that have built a business together, and now they're saying, on the death of one person, please make sure you look after my family as such. And I'll give you an example on that I've used in connection with that, where in terms of the shareholders agreement, they said, if I die, you'll continue to pay my wife a salary as if I was still here. That then brought on a lot of other complications. So it actually wasn't a shareholders agreement. It was almost a succession planning document. And the other thing I do want to say is, if you've got a business trust, and let's say, for instance, A and B are business partners, and A and B set up trusts, 99% of the time, A and B are trustees of each other's trusts as well. Then A dies. Now B's got to negotiate with A's family members a good price to buy the shares back if there isn't a valuation done. But remember, B's also the trustee for A's children, and he's got to do the best for A's kids. So if there's ever a conflict of interest or a split personality or multiple personalities, folks, that's it. If you've got partners, yes, trust your partner, but he's a business partner. He may be, let's say, for instance, an advisor to the family as such, and he can certainly step in, but don't necessarily make him the replacement trustee, because you put that individual in a very precarious position as who do they look after? Their kids by negotiating a good rate or looking after, or if they want to sell, or their deceased partners' kids by selling at best price. And then building block number 4, how are we doing on time? We've got another 45 minutes. So we'll go through if there's other questions, but the building blocks, the assurance, deemed assets and retirement products. Let's have a look at that, and then we'll answer the question on the living annuity. So first of all, assurance policies are deemed assets, and they may or may not be dutiable depending on the nature of the policy. So you'll normally find life assurance includes group life, the normal GLA cover, which is usually between 6, 8, or 10 times annual salary. That gets paid out. Normally it gets paid out to the spouse or whoever the beneficiary nomination is on life assurance. Disability, very seldom there's a fund value, but there may be. Then from a life cover, Where the surviving spouse is the nominated beneficiary, it's exempt from estate duty and it can be paid out prior to the finalization of the asset. And that's, the estate. That's a really, really good one if you're going to end up with liquidity issues within a estate. Now, I am pro and anti life cover when it comes to dealing with products as such, but I'm very pro it when it comes to giving liquidity, and especially then having the cover paid to an individual rather than an estate, because if it gets to the estate, then it's still just got to be dealt with in terms of the normal rules as such. Just to give you an example, going back to that, the example I gave you at the beginning of the session where dad died and mom died 4 months later, and I've got the 2 daughters. In this instance, again, when we'd said to the planner, change your beneficiary nominations, nobody wanted to, it wasn't done because they were just being very sensitive. And now the problem is, because there's no beneficiary nominations, the money's going into the estate. So now I've got 2 daughters where we're waiting, they don't have funds yet at this stage. As an executor, you can advance an heir monies for living costs as such. But folks, before you do that, make sure that you know what your liabilities are. You've advertised first and you've got details of who your creditors are, because you don't want to be in a position of ever testing your PI cover because you've now paid out to a person. There's a massive claim against the estate. You can't meet it. And then you've got to go back, especially with your residual heirs, and get the monies back. Collect, your answer is an offshore life policy deemed property. No, it's a foreign asset from that point of view. So again, it's quite a nice planning vehicle, but that's provided that the policy was taken offshore and is paid with offshore funds. Life cover does not form part of a marital regime claim as it's accrual after death. So when you come to do the surviving spouse calculation, or the the accrual system, just quickly from an accrual point of view, it basically means that you run individual estates until the event of death or divorce, then they get combined, then you deduct your entry or your starting value, and whether that is escalated by the CPI rate, you deduct that, and then whatever's left over is then divided by 2. Life cover isn't part of this because your life cover accrues after death. And then if the estate is the beneficiary on a policy, it's paid to the estate, and then it's dealt with in terms of the will. And when I say dealt with in terms of the will, it can either be a residual heir amount, or it can be a special bequest, like for instance, that example I gave you where the ex-wife from 30 years back came in with a claim to say, I'm the beneficiary of this, or in terms of the divorce order. So although it wasn't dealt with in the will, the fact that there was a divorce order, it meant that we needed to honor that and pay that particular policy to the first ex-wife. Then deemed assets, all life cover is estate dutiable except life cover under buy and sell policy, life cover for key man cover being the cost of replacing a key individual in a business, and life cover taken out for contingencies triggered on death. Remember, the owner of these policies is not the person who's died. It's the owner is insuring the life, the deceased as such. A big one, they must have an insurable interest. I can't go and take a life policy out on my 95-year-old neighbor on the hope that that person, that I know my 95-year-old neighbor is going to die soon. I've got to have an insurable interest. And also there's requirements in the form of, at no point in time was the life assured the policy hadn't have been taken out of the insistence of that life assured, and the life assured must not have paid any premiums. And be careful, folks, from an accounting, for those of you of us accountants, from an accounting point of view, often the premium goes against loan account. Be careful. Who's paying that policy? It's the life assured. So don't account for company buy and sell agreements or key man policy via the company account. On a retirement product, pensions, provident, and annuities, that's retirement annuity policies, not your traditional or conventional annuity. This is retirement and or living annuities, are exempt from estate duty, but subject to executor's fees if they pay directly to the state, not the beneficiary. The lump sums withdrawn on death of a member are taxed in the last return of the deceased person. Now, remember, from a taxing point of view, I said you get a deceased person and you get the deceased estate. Your deceased person is essentially that money is accrues on death. So it's literally the day of death as such, that policy kicks in. So if the person died, let's say, for instance, on the 14th of April, as at the 13th of April, you'll technically do your CGT or your deemed capital gain calculation, and that gets included in your deceased person. And then you take your life policies that were paid in. If there's any income tax on that, there shouldn't be because it's estate duty, but certainly your lump sums on retirement or your annuity products then comes in on that last tax return of a deceased person. It doesn't get done into your deceased estate. And then on annuities, 2/3 on pension and retirement annuities are taxed in the annual return of the beneficiary receiving the annuity at the beneficiary's normal income tax rates. So to answer the question, sorry, it wasn't Rose. Just forgive me, I forgot who asked the question with living annuities. Oh, sorry, I can't get back to it.
It was Sean Khan.
Sean, that's it. Sean, you asked the question in connection with it. Thanks, Danny. On your living annuities, either then the annuity, the individual can either have it paid out and then it becomes a lump sum payment. So it can either come out as a lump sum and be taxed in the individual's hands, or it can be expedited over a 5-year period, or it can be paid out over the life of the beneficiary as such. So again, just have a look and see what are your who is the beneficiary, and then what is the better structure in which to do it. As I say, your lump sums are taxing your deceased person, so therefore you might not want to, because you've got your capital gain on death as well, and you've then got, although your lump sum is taxed on a sliding scale, so it's your, I think it's your first one, it's a 300,000 tax-free, and then goes on a sliding scale. So just do the calculations and see where it's best, whether it's you take it out, or whether you take an annuity on a retirement product. Just another one, also have a look and see who your beneficiary is. So if you've got that one that I've said to you that I'm now into 4th generation and we're going to pay the grandchildren huge amounts of money, I've got 2 of the grandchildren overseas, and I've also got a living annuity then from that point of view, and I've got a retirement annuity. Because the monies are going offshore, and now you've got all the new rules and regulations from a tax perspective that an individual's got to be, before you can export your product, your funds offshore, you've got to have been offshore for a period of 3 years. And then also just, although that's an immigration issue, so just again, have a look at what your double taxation agreements are, because if there's pension, you might find that it's also taxed in the host country. So again, just look at your double taxation and the jurisdictions in connection with your retirement products. Then in connection with your pension funds, there's not so many defined benefit funds around anymore. It's now all defined contribution. Defined benefit, in the old days, what happens was, you'll see, and it's mainly in your older generation nowadays, where they define benefit. So dad receives a pension equal to, let's say, 100% of his salary. And on dad's death, and sorry, folks, I know this it sounds really sexist. Somebody asked me the other day, have I got a thing with dads and mums, and dad's always dying first? I don't know, it's just easier to work by example. But what happens is dad worked, he had a pension of 100% of his salary. On mom's death, 75% of dad's salary gets paid out for her remainder of her life, and on her death it falls away. There is no fund value. That's called a defined benefit. Defined contribution basically says, dad worked for 30 years. He amassed an amount of, let's say, for instance, a pension fund of 20 million, and then it's worked on an annuity, or it's worked on a scale basis where he can take 1/3 in cash. The other 2/3 has to be used to purchase an annuity, and there's the limitations on taking out how much you can take out in the form of the annuity. So defined benefit falls away in terms of the rules, and so you only need to nominate a beneficiary for defined contribution pension products or retirement products. And remember, the trustee may also determine who a dependent is. So I've heard of the example where dad only put the daughters on as beneficiaries, but there was a son, an illegitimate son that needed support as such, and the illegitimate son challenged the trustees and was then added on as a dependent. So just because you've got your named beneficiaries on your retirement products, it doesn't necessarily mean that those are the people that are going to receive. That's at Section 37C of the Pension Fund Act. So the distribution and payment of lump sum benefit on the death of a member is colloquially called death benefits. And in terms of 7C, you only find that it can get paid out in the following scenarios: to dependents only, where there's no nominees; to nominees, where there's no dependents; to dependents and nominees. So remember, this is the one where I've said I've got nominee of the 2 daughters, with the dependent being the illegitimate child. That was then added. And then if there's no dependents and no nominees, then the fund literally stays open for 12 months while they then determine if anybody comes out of the woodwork. If it doesn't, then it just goes intestate, and the funds are actually paid into the estate. On this one, again, just remember, when you sit down to help your client and the planner put the estate plan together, remember, you want to wind this up. The longer it takes for you to wind up an estate, the less money you're going to ultimately make in this, because each time you've got to pick up the file, revisit it, have a look, send correspondence, etc. That's all time, and executors' fees are limited to 3.5% of the value of assets, not of liabilities as such. So you don't necessarily want to run in these where you've got dependents, and you haven't done the nominations. Brian, okay, so if answered, please give me your views, pros and cons, costs and flexibility, and possibly reducing administration and having flexibility by creating a will, say, for 50% of the testator's assets, partly for estate planning, but mainly to protect a mature adult child that isn't good at handling. Would go to the other child or the actual. Are the expenses of this worth it, or is it cheaper, simpler, or either more cumbersome? Okay, Brian, I'm going to need to think about that one. Can I come back to you? We might have some time towards the end. I know we've got half an hour left at this stage. I just want to creating a will trust. You know what? A will trust is, and I like will trusts, especially if you don't need to create a inter vivos trust purely because you don't tick any of those boxes in the form of protection, limited liability, but you do want to protect an individual from themselves. Then a will trust is the cleanest and the neatest way to do it. The problem is that you've got to then appoint an independent trustee. And if you're not sitting with a huge amount of assets, so let's say, for instance, you've got an estate of 10 million rand, and then you split it between two, and then you've got then a testamentary trust then for 5 million. And it depends on how old. So again, to answer the question, it depends on how old your beneficiary is. If your beneficiary is, let's say, for instance, young, then to create a testamentary trust for 5 years from a longevity point of view, you're not going to have, your costs are going to eat into it, and you're not going to have the longevity. Therefore, you might want to do a product, and therefore, from a product point of view, you might want to go into a conventional annuity. So there could be simpler and cheaper ways of doing it. Depends on, Brian, answering your question, what is the value of the estate and how old is your beneficiary, as to what is the products that you would use. Then Albertus, let's have a look. Is the lump sum gratuity on death being paid out as funeral benefits to the spouse taxable in the deceased last assessment? No, it isn't, because it's dutiable. It could be, well, it's going to a spouse, so it's estate duty, and no, there's no tax as such on it. It's there should be no income tax if it comes out of a group life, or if it's a policy document. Let's say, for instance, the company. So again, you could have a situation where the company pays a deceased employee and a lump sum amount as part of a package to meet funeral expenses. That could then end up being a fringe benefit, and they might have to do it as a fringe benefit, Albertus, because it's then paid as a consequence of the deceased being an employee, or up until the date of death. So it depends whether it comes out of a funeral policy or a life policy. Then no, it's not subject to income tax. If it's paid out by, let's say, for instance, an employer, there could be a fringe benefit element to it. To all my legal colleagues in the discussion group, I want to say I sound like a lawyer when you go and ask the question and say, is it this? You ask a question and they say, well, it could be. So unfortunately, folks, with every single one of these questions that I'm answering, it could be depending on what is the jurisdiction, what was the nature of the asset. Like I've just showed now with Albertus's one, is it a lump sum that's paid from a life policy, or does it come from an employer? So you've got to go back and have a look at what was the nature of all of those. Oh, sorry, my sharing of the screen. I think everything is popping up. Sorry, it's all clearing and it's coming out now. Oh, shit. There we are. Sorry, it's linked to the phone and it's out. Folks, then the last question, Mervyn, is the process of the life policy immediately paid out to the beneficiary and then included the L&D account? It depends on if the spouse is, no, it's paid out to, it will be included in your L&D account as a deemed asset, and then it depends on who the beneficiary is. So if you remember, Mervyn, going back to the example, if you then end up paying to a L&D account, it's deducted. If it's paid to a a third party as such, it could be dutiable. I think I've answered them. Those are the open ones. Those are the 4 then that we've answered. Okay, then that's the retirement products. I think I've answered, or I hope I've answered all your questions in connection with the retirement products. I just want to work through some tricks and traps learned purely from experience. One of them is issuing share capital in family companies or businesses, such as passive investment companies, property owning companies, or maybe even the family business. Have a look to see the number of ultimate beneficiaries. And then issue enough shares so not as to cause fractional disproportionate ownership. So to give you an example, a client of mine was buying a property in the UK and we had a trust in Mauritius. From our advice from our UK advisors, we were told to actually buy the property in a UK company and have the shares held by mom and pop purely because of our UK envelope tax. So in other words, if we'd held the company, if we'd held the property through a trust structure, we would have been, there's punitive tax, UK tax, or if we'd funded the company from a trust and it was a UK company, because our shareholder was still non-resident, it was punitive. So in this instance, our advice was given that we wanted to set up a UK company and the initial shares were going to be held by mom and pop. So when I was dealing with the UK accountant, he said, as we all do, let's just issue 100 shares. And I said to him, no, we'll issue 120. And he got defensive and said, oh, why? I said, because the mom and dad have got 3 children. So therefore, it's going to be easier to split 123 ways rather than trying to split 100 3 ways, because then you're going to have 34%, 33 and 33, and you've got to pick your favorite kid, which in my instance, I promise is my oldest daughter. And that also happens with life or your pension covers. You have a fractional percentage. So again, just have a look when you're issuing and setting up these structures, have a look as to how many beneficiaries are you particularly going to have. And that comes back to your living L&D account. If you're busy compiling the L&D account and then you see, okay, this asset's going to go 3 ways, but if I do 3 ways, then I'm going to have fractional, or I'm going to have a problem because I've got offshore ownership or whatever. It's a really great way in which to manage an estate plan. Oh, sorry, this join the dots and complete the picture should have been beforehand. So you've now gone through, you've understood the client's wishes and who the players are as such. You've understood the family dynamics. You've gathered the information. Now you formulate the big picture, both for the local and the worldwide assets. You prepared the estate duty computation and the tax computations on death, so you can see if there's any cash shortfalls and how you deal with those cash shortfalls, or whether you've got a dry tax being that you've got an asset that won't necessarily be liquidated or hasn't got an attendant cash source as such, and then you've drafted your output documents. I just want to show you, and that very often I'm asked, why am I an accountant doing all this fiduciary work or this planning work? Because if you have a look, it's actually a law degree. The laws that we've applied, we've looked at the law of marriage, and we've looked at the marital regime. We've looked at contract, especially if you've got loan agreements in place or you've got partnerships or businesses. You've looked at trust law, you've looked at law of succession, and on your law of succession, you've looked at forced heirship, so you're into another jurisdiction. You've looked at the Companies Act in connection with your MOI and checking against shareholders agreements. You looked at the Income Tax Act, and you've looked at the law of persons. So folks, when doing an estate planning, there's a whole lot more to doing it than just saying what is going to be what are your assets, what is your estate duty, and what is the capital gains tax on that. You need to take into account a whole lot more issues especially if, and I always use the comment to say, if you're an accountant, do not play lawyer. Go back and engage with a lawyer. If you've done the estate plan, that's great, but go and engage with a lawyer and give them the instruction. Be open, though, that if the lawyer comes back and says, have you thought about this? Because there might be a law of contract issue, or there might be, I know there's also a law of things. So as anybody, if this is not your field of expertise when it comes to drafting a will, rather go to the experts, get the lawyer, pay the fees, because remember, on the death of an individual, you can't unring this bell. If you've got a will that's not doesn't cater for the needs, or there's other problems that then come out of it because you haven't thought of something, I always say, don't ever be the reason that there's a fight, or that you can't wind up this estate timeously because you haven't considered all of the issues. So if it's not, you can certainly do the estate plan, because the estate plan, as I say, we all know how to do the estate duty calculation, the capital gains tax calculation on death. You know how to gather the assets. You know the difference between base cost and market value. So do the calculation, but when it comes to drafting the documentation, don't use a cut and paste because you know that somebody's used it and there were similar circumstances. Rather get it done properly. Last ones quickly. And then once you've joined the dots and completed the picture, review it annually, if not periodically, or if there's any major life change, like for instance, the event of marriage, divorce. Remember, from a divorce point of view, you've got 3 months in which you change your will. If you don't change your will within the 3 months, then, and you've still got your ex on it as a beneficiary, tough luck, the ex gets it. If there's the birth or death of a family member, a big one is immigration. Folks, immigration, especially if you've got kids or your clients got kids that immigrate to Australia and or the States, and there's a family trust in place, especially in the US, there's a look through and they go back to inception of the trust, not from when the individual immigrated. So before any family member immigrates from a trust, or immigrates rather, and they are beneficiary of a trust, do the planning. Even though it might not be their assets, ultimately they might one day become a beneficiary because mom and dad died and that's the way it's going to go. If there's awards made, be very, very careful and get a professional person in the States and get it state specific, because in the States you've got state taxes, regional taxes, and you've got national taxes. So, and they differ from state to state. So just be careful in which state the individual goes to. And I'll give you an example that we ended up having to challenge the Australian tax authorities, coming back to the question that I think Khalik had in connection with if I've got a dividend and then it becomes retained income and then I distribute it, that distribution we made of retained income to a non-resident Australian beneficiary, the Australian tax authorities basically wanted to tax it at their flat rate of 40%, and we had to jump through hoops and literally go back from inception to show that this was pure retained income that previously had been taxed, and therefore it wasn't to be taxed again. In this instance, we managed to get around it, but we were basically told if you make any other further distributions, they will be taxable. So be very careful. If a family member immigrates, what is the impact it's going to have, and what is the cost it's going to have for your local beneficiaries. So let's say, for instance, on an immigration one, you want to actually wind down, or you want to send offshore that immigrated beneficiary's 1/3 portion of a trust. And again, I'm not saying that trusts are equally divisible by 3 on the death. It's always at the discretion of the trustees. But let's say, for instance, you do want to unwind it, because why keep a South African asset if you've got an offshore beneficiary? But remember, if you now go and sell a portion of those assets to remit abroad, you're in a capital gain. So does the trust bear the cost of the capital gain, or does that beneficiary who's essentially exiting, does he or she bear the cost? So those are questions you need to ask and you need to understand, because all of those have impacts on how you ultimately wind up the estate, and make sure, coming down to our bottom line, you have a happy family. If there's new businesses or immovable properties purchased, immovable property is more for actually offshore, and then obviously from a retirement perspective. I just want to quickly have a look at the questions. I don't understand why I must change my will within 3 months from divorce. What happens if I do it only 4 months? Okay, Paul, you can do it after 4 months, so that's fine. The problem is if you die in month 4 and you haven't changed it, then it goes back to your ex-wife. Does that make sense? So in other words, they say from the time of divorce, an individual's got 3 months in which to change their will. If they don't change their will within the 3 months and they die in, let's say, month 4, then the will as it is goes to the ex. Malofi, let's have a look. Am I right to say that corporatization offers better tax benefits than trusts, but if the beneficiary is made a shareholder in a company, that beneficiary share in your company automatically becomes part of a joint estate when they marry in community or property? Correct, Malefi, that is correct. So you're right, if an individual is the shareholder, then yes, it comes back to one of the first questions I raised on the personal estate. Look at the marital regime. If it's in community of property, remember all of those assets are divided by 2. I always say you've got the case of what's yours is yours and what's mine is mine, but there's also those instances of what's mine is mine and what's yours is also mine. So just have a look and be careful what your marital regime is. But the answer to yours is yes, it's correct. Then, folks, I think that's the Danny, I don't know why this keeps freezing. I'm not sure if it's my side, but all right. Let's just quickly, we've got 15 more minutes. I'll go through the tricks and traps that I've learned from experience. Again, just another one, do the calculations, but using the capital gains tax exclusion on the death or in the estate of the first dying, then when you do the rollover relief to the surviving spouse, remember when an individual dies, they deem to have sold their assets the day before death, and there's a capital gain on all assets, but then there's rollover relief, what goes to the surviving spouse, and on death, your exclusion amount is 300,000. So if you roll everything over to your surviving spouse, then you lose that 300,000. They don't get it. So I know the cash savings is only 54,000, but who's going to snuff at 54,000 now? Even if you just change a portfolio or just rebase a cost, have a look at it. Oh, sorry. And that one, I want to say I've looked at it now. Again, that's in connection with that mom and dad example who died within 4 months of each other. I am going to just, and it sounds terrible, churn a portfolio, but there's stuff that we can do because in the daughter's hands, we want to create liquidity. So I might as well do it first in the first dying's hands, sell a portion of the assets. So what goes to my surviving spouse goes at a higher base cost. The next one, and this is a big one, folks, and this is a schoolboy error somebody can make, is when revoking a will, check against which jurisdictions and or which assets that revocation applies, and then be very careful not to nullify all wills by changing one will. So have a look on the basis that you say, hold on one sec. Sorry, I've got a bug in my throat. where you say, I revoke all previous codicils or any other testamentary dispositions. If you use that clause and you've got an offshore will, folks, you revoking that offshore will. So then you've got the option to say, I revoke all previous wills or other ones made by me relating to my South African assets, or made by foreign assets only, or any one relating to my immovable property, let's say, for instance, situated in Spain. So be really, really careful. Do not, and if you're taking a will instruction, ask the question, have you got another will? Yes. Have you got other wills overseas? If yes, then be careful how you deal with it. If yes, ask for a copy of that will, because you need to know what the left hand's doing for the right hand, so that you make sure that you actually distribute or you wind it up tidily, because you could make one change here that could affect a beneficiary allocation overseas. And I'll give you a real live example where we've used that. So we had a daughter who immigrated to the States, and before her immigration, we did the necessary planning to get her out of the trust. So we had no look-through, so she wasn't a beneficiary of the local trust. So therefore, from a will point of view, Dad then kept a large, let's say, for instance, it was 1/3 value that would have ultimately gone to that daughter. He kept that in his own name. And therefore, when we did Dad's will, the other two daughters were excluded from his will, because remember, we'd taken this monies out so we could look after the offshore beneficiary in the US. So you don't want to then go and revoke a will and then say my residual heirs are my children, because you might undo the planning that's been done during the time. So again, just know your client and ask those questions. And then, as I said, from a Portuguese one, you need to sign at an embassy office or consulate, and it's also got to be drafted in Portuguese. When compiling the L&D account, oh yeah, this is one that I've done with the CIPC. Get the CIP statement using the planner's identity number. It might not tell you the shareholding, but it certainly tells you if they've got CCs in companies and they're members or directors thereof. It's easier to deal with it during their lifetime. And also ask your clients, and I know you might end up compromising yourself from the point of view of ask the question, are there assets that haven't been disclosed? Because this example that I'm giving you, where we've been queried by SARS, where they've looked at the tax statement of assets and liabilities and said, well, it's never been disclosed on the tax assessment during the deceased's lifetime. Now you've got this asset here, and then they've gone back and we've had to, and we weren't allowed to apply for a VDP. Why not? Because it was brought to our attention by SARS. So we then had to open the prior year assessments and pay the tax and pay the penalties on underestimation and non-disclosure. Look, we negotiated, but you don't want to get caught with not knowing what's happening. Sifting through the documentation brings out so many worms and woodwork. So having that L&D account and creating that electronic vault, it's really a nice way to manage your clients and manage your work as far as winding up the deceased estate, and then managing your client as such. I've said to you on the beneficiary nominations, so just be careful if you've got a minor, those funds get paid out to the minor or to the minor's guardian. And so if you want to protect the assets and you've got minors still, rather have a testamentary trust and then have that endowment policy paid to the testamentary trust. And then only when the individual becomes a major, what is the major? Child over the age of 18. And then you provide a testamentary trust, you have the endowment paid to the estate that goes into the will trust, and then you manage it. And then the disclaimer on the basis to say, I've given you the policy. I haven't added it to the slides here, but please remember, every single client circumstances are bespoke, and there's not one family or succession plan where it's one size fits all. So if you cut and paste any of the documentation, and as I say, I'm of the view that let's provide those trust deeds. But if you're going to use my trust deed as a template, rather spend some time with me and let me tell you why I've got those clauses in the trust deed, so that one day, let's use, for instance, I've in some of my trusts recently that we draft, we say that should a beneficiary at any point in time become either a US or Australian citizen, then all benefits freeze at that stage, and there's all discretionary powers are terminated. Why do we have that in? We have it because I've explained to you about the immigration. So don't go and do a cut and paste if you've literally setting up a inter vivas trust for a specific beneficiary to maintain that beneficiary and pay maintenance. So as I say, folks, I'm all for using templates and precedent documents, but don't cut and paste. Understand A, why those clauses are there, and B, understand your client. And that is it. It's been great. I want to say, I am going to put my video on then quickly. I love talking to people and I love doing this and the planning. It's sad that we're not at the Old War Memorial. As I said to Danny, I always enjoyed the snacks that came out. There was always great snacks. So I'm very sad that we're on face-to-face, and hopefully next year we can actually do face-to-face. But thank you, folks. I hope it's been beneficial. As I say, it's not a technical one. This is being practical. It's a practical implications of winding up an estate and having a look at what makes it easy for your client. And for me, the lady that I did the mentorship this morning for, I said to her when she was going out to say, how do I market to new clients? Folks, your best client is an existing client where you can get additional business from that side. So keep marketing to those initial clients, and you'll find, you'll be surprised, you go in and you complete a tax return, you go and sign the tax return come year end, and then you say to them, so when last did you update your will? You're going to get a will instruction. And then as you're unpacking that, you might see that, oh, there's something else. Can we not have a look at this? So I'm not saying go and sell unnecessary, and I'm certainly not a salesperson from that. But if you entrench yourself with your client and you've got a great relationship, that client and their family will stay with you. And what better way to keep a professional practice than to have to start at zero at the beginning of every year, because it's transactional based. So Abashis, thank you for your message there. It's been great speaking to you. I've enjoyed it, and Danny, I would love the opportunity to come back and talk on trust. Trusts are my passion. Let's use them. There's lots of other planning opportunities. The offshore side, it's a minefield, but you can navigate your way through it really easily if you just know what to look for and what the questions are that you want to ask.
No, thank you again, Cheryl. Yeah, that was great. Yeah, no, I was thinking about it. I was going to discuss it with you when we wind everything up tomorrow, but we'll make some plans for next year to do trusts, and then we'll carry on with more seminars going forward. I've gotten used to doing these webinars, but also it would be nice to go back to the War Memorial.
Yeah.
But we'll work out a combined thing if we are back to live. So those who are still around the country can still join in.
Oh, yeah.
Because it's been nice to have people from Cape Town and Bloemfontein and all over joining.
Well, you know what? As somebody said to me the other day, with regards to seminars, if you have a look at it, I don't think there was ever 80 or 90. I think at one stage it was 93 participants. You didn't have that necessary at the War Memorial, but look what you've got now, and there's a wider reach. So I understand. So folks, thank you. It's been great.
Yeah. And then, so then on admin side, we will me and Stan will get together, we'll discuss, and we'll finalize all the paperwork for certificates, do our admin, and then as we have said earlier, we have Jackie Aronsa next week, and in 2 weeks' time we have an ethics seminar. So we'll see those who are joining for those 2 seminars in the future, and all the best. I think we're going to end it. It is almost now 2 minutes to 4. We did good timing today. Any last minute questions before I close off? I'll give you 2 minutes to wait. I think everyone's pretty much logging off if they've not got any questions. And there's just a lot of thank yous I'm seeing in the chat and the questions.
Great. Thank you, folks. All right, magic. Thank you, Danny.
Cheers. Thank you. Cheers, everyone.
Go well. Cheers.